For anybody in the audience, we're just waiting for our official secretary to have her connection working properly.
Here I am. All right.
Okay, Francine's in.
Okay, welcome, Francine.
Hello.
Excuse me. My name is Ralph Engel. As chair of the planning board, I have confirmed with our counsel, Lisa Hockman, that tonight's meeting has been convened in accordance with the governor's executive order 202.1 as again extended, which order suspends certain provisions of the open meetings law to allow municipal boards such as this one to convene meetings via video conferencing. Francine Brill, as planning board secretary, please confirm that tonight's meeting itself has been duly, even part of been duly, and please state for the record whether such notice has been posted and published.
Yes, they have. Everything's been duly noticed.
Thank you. The public hearings that are continued tonight or open tonight will be conducted in accordance with the governor's executive order number 202.15, as again extended. The notices relating to those hearings provided instructions for members of the public on how to view and participate in tonight's public hearings, assuming that those notices were appropriately posted and mailed. The public has been provided with the ability to view tonight's planning board meeting on television and online. This meeting is being broadcast live on LMC TV, which is channel 35 on Fios and channel 76 on Optimum. It is also online at lmctv.org. Anybody who wishes to call into the public hearing portion to comment may do so either through Zoom or by calling 1-646-876-9923. Repeat, 1-646-876-9923. A transcript of this meeting will be available at a later date. Francine, for the record, please call the roll to confirm which planning board members, including alternate members, are present tonight.
Ralph Engel,
Speaking here.
John Cuddy,
Here.
Ira Block,
Present.
Elizabeth Cooney,
Here.
Ron Mandel.
Here.
Ron, I
We
can't
have-
hear you.
Pardon?
Ron,
I'm here.
Sarah Dunn.
Here.
Thank you.
Thank you. So we have a quorum. In addition, the individuals representing the town this evening
Ralph,
should please identify themselves, name and title, so that the viewers may know who's who.
Lisa.
Robert Wasp, town engineer.
Lisa Hockman, counsel to the planning board.
Rena Fiddleman, liaison to the planning board from the town board.
Francine, it's Ed Papazian. Did you call my name?
Oh, I didn't see you. Sorry, Ed. Thank you.
Very good.
Hi, Elizabeth Atchison, environmental planner for the town of Mamaroneck.
Anthony Oliveri, consultant engineer for the town.
Ralph, you're muted.
We're all muted.
You're
Ralph, you
muted.
need to unmute, Ralph.
Ralph, you're muted.
Muted.
There you go.
Finally, not sure what happened there. Okay. In any event, sorry. First item on the agenda is a review of the minutes of the September 9, 2020 meeting. Does anybody have any comments with respect to those?
I just have one typo on page 14. The very last line. Whether the antenna arrays should be painted. It says painted.
Good point. Anybody else, Ira?
I have a few. Page 13, the first line says his only concerns should be concern. 3 or 4 lines below that, there's a statement attributed to Liz stating that she does not believe the trees will, says not survive construction, but my recollection is she said her belief was that they would not survive construction, correct, Liz?
That's correct.
Okay, so that not has to come out.
Anything further, Ira?
I have a few.
On page 10, the second paragraph before the motion, the line begins, the board discussed the memo issues should be issued. Page 9, third line, the word should be satisfaction, singular, not satisfactions. On page 5, Liz's last name is misspelled. And I think it's misspelled somewhere else. I think I caught, this is not a typo, but, it's Liz's name is misspelled on page 2 also. But this is directed to Francine. On page 2, the public comments. At least as I read the remarks you're attributing to Mr. Morse, it didn't seem to read fluidly.
Ira, I think I have a solution to that.
I know you would.
So I think it should read Darren Moss, comma, the president of the Pine Brook Association, comma, stated that there has been an increase of test drives, comma, whether by potential customers or by employees of the applicant, period. Test drives may not go into certain areas of the neighborhood, and it is a big safety concern.
Makes sense?
Sounds good.
John, would you be able to send that language to Francine in case she didn't catch it? Or Francine, would that be helpful to you?
Good.
And on page 4, the chairman's name is misspelled.
Also on page 2,
That's all I found.
so on page 2, where it speaks of Mr. Engel stated that the plantings and it should be striping, not stripping of the parking lot. Page 3, really the question I have is, are these two resolutions or a single resolution? If you look on page 4.
There are two resolutions.
Two
There's a
resolutions,
site
one
plan
approving it.
amendment application and an application for a special use permit renewal.
I understand, Mr. Chairman, but the resolution regarding the site plan amendment is fashioned as two resolutions, and I'm really wondering whether it can't be collapsed into a single resolution. It looks like there are two approvals. On page 4, there's a resolution to approve the application, and then further down, be it further resolved that the board approves the application subject to following terms and conditions. That probably should be collapsed into a single resolution.
But Lisa, you want to respond to that?
Yeah, so I see, okay, I think you're correct that well, there are two separate resolutions, one for the site plan and one for the special use permit. But I think what you're pointing out is on page 4, we don't need the be it further resolved.
Correct.
We can just say that the application is approved subject to the following terms and conditions. So we'll make that change. Francine, do you see that? I can,
Yes.
okay.
Wait a minute, on page 4, now therefore be it resolved is the one you're talking about, which refers to the drawings?
Right, we can bring up subject to the following terms and conditions. We can just move that phrase up to the now therefore be it resolved.
So for a site plan amendment, don't we have to refer to the drawings with the site plan amendment?
Well, we will. It'll refer to both the drawings and the conditions.
Okay, so you're gonna have both in the same place rather than,
Yeah, I mean,
There should be a single resolution approving
The whole
subject to the conditions. That's all I have, Mr. Chairman.
sorry, I'm not sure what I'm missing here, but it seems to me that the approval of the site plan amendment must refer to document showing the site plan amendment, which happens on page 4, does it not?
yeah, it will refer, so the way I understand it, it will just be modified so that first resolved paragraph refers to both the plans as well as the conditions.
So you're talking about, and the one that starts being further resolved is eliminated?
Right, and we move from that paragraph up into the now therefore be it resolved.
Okay,
Reference to the
subject to.
Well,
Fine.
just as a matter of readability, maybe that now therefore should be revised to say, now therefore be it resolved that the planning board approves the application as reflected in the plans identified below, subject to the conditions listed below.
Yeah,
Sure.
combine the two.
yes.
Okay, sorry, I didn't understand what was sought. Anything further, anybody? In that case, can we have a motion to approve the minutes as modified?
So moved.
Second,
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 all in favor, raise hands, please.
aye.
Aye.
Anybody opposed? Any abstentions? Unanimously approved. Okay, next item is just so that everybody understands, including everybody in our audience and the applicants, that there is a moratorium in effect in the town with respect to what's colloquially called, rock removal, which is really also breaking of rock. And that is, so far as I know, potentially going to run through the end of the year, although it doesn't at this point. Sabrina, am I wrong at this? That's a potential end date at the moment?
Yes.
Okay, so for any applicant who plans on doing any of this, they should be advised that they cannot do that kind of work for the time being. Okay, next item, which is the first numbered item on the agenda, is Pepe Porsche. Lisa, would you bring us up to date on that, please?
Yes. The attorney for the applicant who presented on behalf of the applicant last month sent me an email that I'd like to read into the record. And it says, pursuant to our discussions and emails and the agreements reached involving and between William Maker Jr. Esquire and Lee S. Whitaker Esquire with respect to Porsche, please be advised that Porsche, for the purposes of reaching an amicable resolution of all matters without prejudice to all parties, agrees to withdraw the application for renewal of its special use permit until the decision order in the adverse possession litigation commenced by Mr. Whitaker is decided. So essentially, they did agree to pursue an adverse possession proceeding, and Mr. Maker has confirmed that that is moving ahead. So we agreed to strike the item from the agenda. They have formally withdrawn, and they will come back if and when they're ready to pursue the special use permit.
And
So what happens in the meanwhile? Are they in violation of an expired special permit?
Rob, can you speak to discussions that were had with the building inspector?
I believe that the discussion was that, as this is currently before the court, that that there would be no violation issued for the interim, assuming that this moves forward in the time frame that has been laid out. I was not party to any of the most recent discussions that could have happened in the last 2 weeks, so I'm speaking just upon prior knowledge.
I think it's not quite that open-ended. As I understand it, this is a 60-day deal. From what the day it starts, I'm not sure. But that the town agreed via the town attorney that there would be no enforcement for 60 days and that the matter would be reconsidered by the town at that point. So it's not an open-ended, they can proceed without a special use permit forever, but at this point they can proceed without one for 60 days from roughly a week or so ago.
And is the town pursuing its appeal?
Yes, the town is still, that hasn't been, our appeal has not been withdrawn. And because the application has now been withdrawn, at the time that whatever was agreed between the building department and Bill Maker, when that period elapses, this will not be pending before the planning board. So the building inspector will be able to pursue any enforcement action, because typically the courts won't do anything if it's pending before the board, but it won't be pending before the board because they've withdrawn the application.
Does their withdrawal somehow moot out our appeal?
No,
No.
Okay.
not
No.
according
In
to
fact,
Bill
I
Maker.
discussed that with Bill Maker and he's comfortable with this approach.
Okay.
Okay. Item number 2 on the agenda is
Mr.
60.
Chairman?
Pardon me, any comments?
Yes. I would like to record for the record my view that my sense of the board's position is that if the application had not been withdrawn, it would have been denied. I can't speak for every other board member, but I can say that given the additional information that was furnished by our counsel, my vote, if a vote had been taken, would be to deny the application. on the ground that there's been complete non-compliance by the applicant with the requirements. I don't know what relevance this has, but I did not want to let the opportunity go by and to stand silent.
Right, well, I just want to also get on the record, Ira, that if and when this comes back, that you will revisit the application under the circumstances that it's resubmitted, because it will be at that point a new application. So my expectation is that you will be asked to review this application when it comes back, and you'll need to review it on the terms that it's submitted and the circumstances that surrounds its submittal.
There's actually also another factor to this, and that is that as submitted and utilizing property they don't own or have any right to use, so far as we know, we may have no jurisdiction to approve the special use permit in the first place.
Yeah, I would just not, I think we should leave it at the fact that it's been withdrawn and not speculate about how or whether or under what circumstances it will return. For the time being, it has been withdrawn and it will be evaluated anew once it gets resubmitted as a new application.
Yeah, as to enforcement, that is left to the town, not to us.
Correct.
Okay, next item on the agenda, 613 Fifth Avenue. Okay, that is the renewal of a special use permit for an auto repair facility. And each of you should have received in your email today a photograph, which I happen to take because I usually do check out sites before meetings. And the photograph shows a violation, not a violation issued by the town, but a practical violation of what would be the fifth condition in the proposed resolution that was circulated for review for consideration this evening. And that same condition is in their present special use permit. And I can tell you, just as an ordinary citizen who drives down that street, this is most certainly not the first time that violation has happened. In order to issue an actual violation, it has to be witnessed by an appropriate person from the town building department. Apparently, having the police witness it is insufficient. So when what will happen, I don't know, but I do want to suggest that given the fact that we have evidence, photographic evidence of a violation of an existing condition today, the same day they're coming before us, we may want to consider, after that we give them a chance to present to us, whether we want to or do not want to renew the permit at this time. Is the applicant around? Can we bring him in or her?
If anybody from the application is in the Zoom meeting, can you please use the raise your hand function to let us know that you're here?
This is City Park Service Station.
Okay, I think I have somebody. Hey, Mr. and Mrs. McKean, can you hear us?
They're on mute.
Yes, sir. I'm here. Hello?
Thank you. Yes, we can hear you.
Yes, sir.
Okay, I think, why don't we start with a motion to open the public hearing?
Mhm.
Moved.
And then we'll let the applicant make his presentation and respond to it as appropriate.
Francine, can you please confirm for the record that this application was duly noticed?
Yes, it was.
Okay, may I have a motion to open the public hearing on this application?
So moved.
Second.
All in favor?
Aye.
Aye. All opposed? Abstentions? Unanimously opened. Okay, Mr. McKean, would you please make your presentation?
Uh, I don't know what you want me to say. What was the violation over there you saw, sir?
The issue, sir, is that there's been several instances where vehicles have been observed parking in an area that's striped for no parking.
Oh,
On your
okay. That's from the, whatever vehicle he see, it's not belong to us. That's the construction workers building the building next to us. They park their vehicle on the other side. It's not our vehicle. All our vehicles are parked inside our parking lot. Wherever you guys ask me to put those stripes, we don't park even in top of the stripes. That those vehicles are parked is not our vehicles. That's they are building some, how you call that? Next to our building, there is a new building coming up. So
The storage building.
storage building, they are vehicles.
Well, are you saying that the parking on your lot, which extends into and sometimes blocks these yellow striped area, is people who are not your people?
No, sometimes they park over there. If they see a empty space, they park and they go. And I want to know, you talking the one on our side or opposite to our side? Because
Talking about your side.
no, there was if you saw like two vehicle next to our building, that's our vehicle. But whoever came like a week ago, they told us since they put a fence on the other side where the new building is getting built, so we can park over there for time being. That's why we parked. Otherwise, we don't park over there.
Well, sir, this afternoon,
Mhm.
around lunchtime, I was at your site, as I frequently am, at sites when we have meetings, and there were two cars parked from people from your place because they were standing talking to a third person from your place.
Mhm.
And when they saw that I was taking a photograph of the cars parked where they're not allowed to be parked, they jumped in their cars and took off. They did not go to any adjoining place. They plain took off. So it seems to me at this point that there's a condition to your present special use permit, which prohibits exactly that. It prohibits parking in the no parking zone on your side of Fifth Avenue, which is a condition that you are not enforcing.
I'm sorry that when you came, me or my manager wasn't there. So when we were there, we really strict. But sometimes the customer come or there's people who bring sometimes parts for our garage. They quickly park over there. They come. So I'll make sure this is not happening again.
Anybody else have any from the board have any comments with respect to any of this?
Is there any way you can impose a bond for violation of that particular section of the special permit, such that if there is a violation, you can pull a bond?
No. The violation has its own consequences. So I don't recommend basically bonding for violations. I mean, there is an enforcement procedure that the town can follow.
Well, in that regard, can one tie the approval of the special use permit or the expiration of that permit to the earlier of the a, say, the 2-year anniversary, which is typical, or the violation of any of the conditions of the permit, which means that if this condition were violated, the permit would terminate.
Without saying definitively no, the reason I'm hesitating is for 2 reasons. One, I think that presents an enforcement problem in terms of, you know, how I do think that this is something that should be pursued from an enforcement perspective. But even if the special use permit isn't terminated immediately upon violation, there can be a process by which the applicant would need to respond and maybe pay a fine, and that there is a mechanism for it. And I just think as it is, that's why these special use permits are 2 years. If it gets documented in the file and there's a prolonged, you know, pervasive problem with it, we do have an opportunity in 2 years, which, you know, to address it. But even in the interim, the town can pursue it as an enforcement issue. Rob, is that correct?
Yes, that's correct. I was just going to say that.
Cancellation is rather harsh, specifically, particularly if in fact they don't have control over some of the cars that are in front of their facility. If somebody else is dropping off parts, these people can't dictate where they can tell them to move, but in fact they don't control that particular vehicle. So I think any pulling of the permit because of a violation would be too harsh.
Well, just to be clear, so the area that's striped is actually not on the street. It actually is up on the sidewalk. Hence, you know, any vehicle parked that is parking on private property is, you know, therefore trespassing, whatever the citation is for that. I was just going to say for Mr. McKean that just to be aware that, you know, since the building department is now aware, this has become a concern, that we will be checking up on it. So I would ask that you please do talk to your management and make sure that everyone understands that area must be kept as a no parking zone.
Well, can I ask a question? The town has a parking enforcement officer, and the parking enforcement officer is regularly, roughly 1.5 blocks from there in the Washington Square area of the town, enforcing parking regulations. It would seem to me that I think it's a he, could be asked to take a ride down there periodically and see what's going on. And the parking enforcement officer could issue a ticket simply for violation of a no parking.
But if the striping is on private property,
No,
any,
the photos that you saw, the photo you saw was cars that were not on private property. They were parked on Fifth Avenue.
oh, okay.
And where a sign specifically says no parking either direction. And that's why the special use permit in paragraph 5 or condition 5 specifically deals with this to avoid what I happened to see.
So the striped area you're talking about is not on the applicant's property?
The striped area is on their property. And I will say most of the time they honor that. This is parking on the street, which on Fifth Avenue is somewhat a more significant thing because the town prohibits parking there, and that's where they were parking.
Well, they weren't parking. They indicated that people
Cars
who
were
were
parked
off
there.
were parking.
Yeah.
Well, somebody was parking who was dealing with a third person from the place in question. How they were dealing with him, I didn't stick around
Okay.
hand over heels.
Isn't the striped area striped up behind the curb? So it would be between the curb and the property line? Within the right of way, like a sidewalk area?
No, it's the area in question. There's no striped area on the street, like a crosswalk, if that's what you're asking.
No, that's what I agree, that the striped area is up on top of the curb, between the curb and the property.
Right, where a sidewalk normally.
Where a sidewalk would be, right. And cars are parked in that striped area as well as within the street. Is that what you're saying?
No.
Is that town property or is that private
The
property?
striped area would be in the right of way.
But you're not saying people were parked on the striped area. They
No.
were parked on the public thoroughfare, the street.
Well, there was a picture that was circulated that showed cars parked against the building and cars parked along the curb line, kind of like double
Yeah.
parked there. So the cars that go along the building are parked behind the curb, still in the right of way, like where a sidewalk would be. And the cars in front are parked in front of the curb where there's no parking signs posted. So
Yeah, in
you-
fact, you're right. The red car in the picture is parked where the sidewalk ought to be.
And the internet's a wonderful thing. If you look at Street View, you'll see cars parked on the striped area on Google Earth with hoods open like they're being worked on.
Well, personal view is that we ought to give the owner a chance to rectify this.
Well,
I don't know if others agree.
I do.
But, Mr. Chairman, if you're focusing on condition number 5 specifically.
That's correct.
Seems to me we're making as a condition of the special permit that there be compliance with a townwide ordinance.
Which would apply anyway, but yes.
That's correct. So to violate condition number 5, one would have to establish not just that the vehicle was parked or present where it shouldn't be on property where the town could issue a traffic violation, but also that it was intentionally placed there by someone in privity with the applicant. Talking about enforcement obstacles, that's a very substantial one.
So what's your recommendation?
My recommendation is that condition number 5 is not that meaningful. It would be better if we encourage the applicant when someone is parking there to call the town police or something. I don't know if vehicles can be towed away from there. Maybe that would be more of an incentive. It's more likely to get compliance with that, I think, as a practical matter than leaving condition number 5 in.
Well, let me just tell you that when I was there, so was a town police car. And the town police car was parked on Valley, then drove past all of these cars while they were still parked there and took no action. I didn't ask them to because it ain't my job. But I don't think relying on the town police to enforce this is going to work.
Well, my suggestion is that we talk to the to Mr. Altieri and let him have a conversation with Chief Criasa, and maybe the circumstance will change.
That may solve the problem. So are people generally in favor of renewing this permit with the same conditions and in the hope that the applicant will use his best efforts to enforce all of them, including number 5?
I would like to ask the applicant why it was that he needed to be reminded by Mr. Wasp that the applicant, his special permit had expired 6 or 7 months prior, and then it took him another month, a month and a half to get an application into us.
Excuse me, sir. This is first time I'm renewing this application, and in our corporation, every 2 years, every year, the presidency is changing. Under my presidency, this is the first time. So somehow we had a communication problem. I didn't get any paperwork to submit to you or saying that I have to submit. As soon as I got these papers, and I did my best to submit the application. And I can promise this won't happen again. And I have experience a little bit, and I'll be working with Ms. Francine.
But 2 years from now, will you be the president or will someone else be the president?
Hopefully me. If not me, I'll let the other guy to follow up with this.
Thank you.
Thank you, sir. Thank you all.
Okay, does someone want to make a motion to adopt the proposed resolution extending the special use permit in the form in which the resolution was proposed, was circulated among the members. Ron,
Motion to close first.
is there a second?
We have to motion to close it.
Oh, I'm
Close first.
sorry. I'm sorry, we have skipped one. Yes, first a motion to close the public hearing. Well, wait a minute, before we do that, are there any members of the public who wish to say anything in connection with this application?
Okay, anybody in the meeting as an attendee, please use the raise your hand function if you wish to speak. You can also email the town through the town email account, publicuc@townofmamaroneckny.org. I believe Liz has that email account being monitored. So Liz, if anybody wrote any emails.
And then Rob, can they also dial in with the phone number that's posted?
Correct. Yes. As some may have noticed, I was able to add an additional attendee as a panelist that shows a slide with the call phone number, meeting ID, and passcode. So anybody watching this can access the meeting using that number and credentials.
Anybody contacting us?
No emails.
And nobody has raised their hand.
And no phone calls received. Okay, now a motion to close the public hearing, please.
So moved.
Second,
Second.
all in favor? Aye. All opposed? Abstentions? Unanimously approved. Now, consideration of the resolution, which was circulated with the packets of material. Does anyone want to make a motion to adopt that resolution?
So moved.
Second,
Second.
all in favor?
Aye.
All opposed? Abstentions? Adopted. Thank you, Mr. McKean. Please do what you said you were going to do.
Okay, thank you.
Okay, the next item on the agenda is 5 Cornell Street. That has some current event items which we'll be discussing, which will affect this evening. But first, I guess, Ron, let's see who wants to join our meeting.
Okay, I'm in the process of promoting members of the applicant's team to be panelists.
Good evening, everyone.
Good evening.
Hello.
Good evening. Is everybody from your team present at this time?
You want to, maybe Greg Cacciapoli, is he on?
No,
Okay.
I do see a Becky Ziff as an attendee. I believe they're part of your team, right?
Yes, that's one of the applicants.
Okay.
All right, if Greg's not there, it's not a problem.
Elliot, are you guys ready to go?
Yes. Leo, did you want to start?
Sure, just for
Actually,
the benefit.
let me say something before, so that it's just clear on the record before this begins. There is a requirement in connection with applications for site plan review of notice being posted on the property in a specific manner. There is no notice posted on the property in connection with tonight's public hearing. Accordingly, it will not be possible, no matter what it is we may discuss, for this board to vote tonight in connection with the application. Why there was no notice posted, I leave to all of you, but there is no notice. It was, the place was reviewed by Rob Wasp and me today and photographed, and there is no notice. There also is another problem with Rob, I think you ought to raise at this point.
Thank you, Mr. Chairman. There's an important issue that we need to discuss tonight. The building department was alerted to possible unacceptable site conditions at the number 5 Cornell Street property earlier today. A site visit was conducted, which confirmed the presence of a large amount of fill material that's been brought onto the property. The property currently has permits for demolition of the house that was formerly there, as well as an erosion permit associated with that house removal scope. It would be estimated that there's roughly between 1,000 to 1,200 yards of boulder and other material that's been brought into the site outside of that permit scope. This is a serious violation which has resulted in the issuance of a stop work order at the end of the day today, and will need to be addressed moving forward.
I have to tell you one thing. There was several meetings done on this property. The neighbors all know about this property. So the notification on this, obviously, everybody knows about this application. So I don't think it's fair for the ZIFs to not to vote on this matter, because the public knows about it, and the public is actually gonna, some of the neighbors gonna be in this meeting. So I don't think it's fair for this. With regards to the material on site, it's boulders that we secure for those retaining walls, because sometimes you can't really get those boulders, and it's very expensive if you need to buy them. So we had a chance to secure them, and we just secure some of it. I mean, we're obviously gonna need more material of those rocks, but I don't think it's fair for the ZIF not to vote on this application. This is dragging for too long. I mean, I've been in Scarsdale, building in Scarsdale and Mamaroneck. I've never had an application that took so long to get approved. I'm sorry to tell you, it's really the process. I know COVID, we had COVID in the meantime, but this is beyond what I expect for an application to be approved. I go to
Mr. Amador, let me just make something clear.
Yes.
Both of the items that have made it impossible to proceed are the fault of the applicant or the applicant's agents. The non-posting of a sign, the sign is required by the code of Mamaroneck, and it was not posted in connection with this, and it was the applicant's job or the applicant's agent's job to post it. It was not done. That is the requirement for jurisdiction to proceed.
I just wanted to say the sign was posted. If it disappeared during the last few weeks, I don't know what happened, but there was a sign there at one point.
Well, there may have been one at some point, but there was none there now, or none there this
Even
early
the last meeting.
today. And the concept of you brought rocks and other things onto the site without a permit because you got a better deal does not have anything to do with the fact that you brought this all on the site without a permit. Permits come
Correct.
first. The moving of the rocks comes second. So with respect to what we're talking about, we are perfectly happy, I believe, to discuss various other issues that relate to the application. But we will not be jurisdictionally able to take any action this evening. And we will not be able to take any until the violations that have presumably are about to be issued, the stop work order, and correct me if I'm wrong, Lisa, all of that stuff has been lifted.
Right, you can't issue an approval for an application where there's outstanding violations, and you do have to comply with the requirements of the notice code. That's chapter 144 of the town code. It relates not just to notices to be mailed to residents within a certain radius, but requires the posting of a sign 14 days before the application is to be heard.
By the way, the last meeting, you guys didn't see the sign. The sign was there, and we ran last minute to just adjust it so you guys can see it, and we took pictures. So I'm sure the sign is there. It's just Probably you guys didn't notice that.
It is not there. It's not lying on the ground. Actually walked
and
around to
it-
try to find it so that we wouldn't be in this position.
And-
That was before I'd heard from Rob about those violations, the other ones about the materials. I actually looked because I thought maybe it fell down. I looked on the thing that has the electrical stuff hanging from it. There was nothing there. I looked around on the bushes. There was nothing there. There was nothing. And the requirement of keeping it there is not on the town of Mamaroneck, it's on the applicant.
So, Mr. Chairman, if I may, I wasn't at the prior meeting. For the record, Leo Napier, counsel for the ZIFs.
I figured.
The public hearing was opened at the prior meeting, and presumably all proper notices were mailed and affidavits were supplied and certificates of mailing were supplied. Without having reviewed your code in detail, I'm not presently certain whether or not there's a continuing requirement to renotice each subsequent meeting. But I'd like to point out that generally speaking, municipal boards, if you notice the first meeting that's deemed sufficient to alert the public, then it's up to the public to track an application after that if they're interested in it.
Well, I'll have our counsel respond to that.
Yeah, you can check our code. It requires that it requires that the sign continue to be posted. If the public hearing continues to another meeting, it does not require a new mailing to be sent.
Right, the sign then gets modified with the new date of the update, the date of the continued public hearing. Otherwise, it's the same sign. Okay, as stated, it doesn't
Just one
require another mailing.
question. Rob, did you independently visit the site and were you able to see whether or not a sign was there?
I did. I was there this afternoon to observe the fill issue, and at that time, no sign was witnessed. And just to focus our attention on the greater issue here, whether or not a sign was or was not there would not abate the issue of the fill placement. We're not talking about a couple loads of trucks here. We're talking in the order of 60 to 80 truckloads of material.
So sort of bottom line, even if there had been a sign, which there wasn't, we wouldn't be able to proceed anyway. But we can proceed with discussions because there are various other issues with respect to this application that can be discussed tonight. And hopefully all of this can be resolved in time for the November meeting of this board, which is on the 11th. Which, by the way, would also have to be posted on a sign. Same sign as last time, with now the November 11 date on it.
We can be sure to take care of the notices. If we could proceed to talking about the application, that would be much appreciated.
Yeah, I mean, we don't want to have all you here and waste your time totally. Okay. At the September meeting, a request was made by this board to the applicants to have a discussion with their neighbors who had appeared at the last public hearing about ways to deal with the proposal that would be acceptable to them. It's not that they get to make the decision. It was an attempt to have everybody agree on something which the board potentially could agree on also. As what happened with respect to those discussions, if they ever took place at all?
I could take this if you.
Okay, Elliot.
Yes, a discussion was had with Mr. Friedfertig at 3 Cornell, as well as Mr. Friedfertig had just this past weekend talked to Mr. Kaplan, who was at 1 Cornell on the corner. We did prepare a plan that showed the grading across the property all the way to the property line at 1 Cornell. We did submit it to Mr. Wasp. I have it here. If you want to share, I can share my screen and we could look at it if you'd like. So if you allow me to share.
Elliot, you should be able to share, but just for everyone's clear, so this plan was received last week, Wednesday, October 7th, which is after our meeting deadline. However, it does remain scheduled for a peer meeting appearance tomorrow. I'm sorry, Friday this week.
Yeah, I mean, a couple of things. As was just pointed out by Mr. Rob, number one, it came in too late for consideration today anyway.
Well,
Item number 2 is that we cannot approve a plan that involves 2 lots with 2 different owners.
Right.
Elliot, if I
Yes.
could just jump in for a second, Elliot. So, Mr. Chairman, there was a modified plan that was submitted that showed the walls being stepped in back off the property. That was put into your packets on a timely basis. It also showed additional screening by way of rows of arborvitae at the base of the walls to screen it from the neighboring property. I think Elliot was skipping forward to a subsequent discussion, which is reflected in the plan that's before you, that is kind of a contemplated plan that would marry the 2 properties. However, that is not our proposed application. That is an application that we would certainly join on with the neighbor if and when the neighbor so decided to file for to regrade their own property. And there has been a meeting of the minds, my understanding, between both the applicant and the neighbor, that plan will be coming before your board at some point in the relatively near future. However, in the time being, we do have a standalone application before your board.
So the application that you have now is the first application, the original application, is that correct?
Correct, subject to the modifications that were put into the plan that I just highlighted, which was to add some evergreen screening along the base of the wall to screen it from the neighboring property. I believe, and Elliot, you could correct me if I'm missing any other changes, but there were a couple of trees that were marked to be preserved that Liz indicated in all likelihood would not survive construction. So those have now been marked to be removed. Our client's intent is to try to save those during construction if they can be, but so as not to present any kind of false hope, we've now marked them for removal and we're going to do our best to save them.
Mr. Wasp, can you tell me, please, were those what's described as a modified plan submitted in accordance with the rules for submissions as to both time and quantity?
The plan that's being described now, which has all development contained just to the number 5 Cornell lot, was submitted electronically prior to the meeting's middle date. The office received a total of 4 copies. 14 copies are required. However, given the other issues that were here tonight,
14 copies.
14 copies.
Just to make it clear to those of you who are not familiar, it's specifically stated on page 4 of the residential site plan checklist immediately above the signatures of both of your clients. Okay, so the idea that they didn't know seems unlikely since they signed just below it.
In any case, Mr. Chairman, given the nature that these were relatively minor corrections and under other circumstances, it's relevant to point out that we might be willing to work with this issue, but there are obviously larger issues at stake tonight that we are confronted with that still withhold the approval.
By this way, the same requirements are set forth on the actual application that was submitted to. So at this point, the only application that could be considered, if any could be considered, is the only application we have, which is the original application. If for the next meeting you want to submit appropriately and timely a modified application, it can be considered at the next meeting. We can't consider an application we don't have.
I think that we are going with this single application for the single lot. During the discussion last month, the neighbor had raised the opinion that he didn't like the retaining walls, etc. And so you had instructed us to go and try and talk to them and come up with a consolidation or combined site plan. But always the applications are going to be separate standalone applications. And we also discussed at the time that if we show the walls and the walls are consistent with the rules and the heights, etc., and that if we delete the wall later on, you had no problems with deleting the wall, but we had to leave it in because if they didn't come to a consensus between property neighbors, that you would be able to approve a standalone. And that's why we haven't, and I don't think we are going to submit a combined application for the two properties. It's two standalone applications, one at 5 Cornell showing the walls. And then later on, if we get to a meeting, because there was discussion about the fill at 3 Cornell may not need to come to the planning board because of whatever rules they were, and that's the purpose of the peer review, that may not even come to you, and that this was a standalone meeting, and that's our application. We are not modifying this grading plan because we've come to an understanding with the neighbor. The understanding is that the neighbor is okay with this, and they'll discuss the revision later on.
I think you're probably well aware that it is the job of this board to enforce the laws that's written, whether or not the neighbors actually approve it. What we had here last time were neighbors raising problems. One neighbor saying, it's not going to be a problem because I want to raise my property too, to match, which is what presumably led to the joint plan. But that neighbor has to come to this planning board separately for his own property and may or may not get permission to do that. If he did get permission to do that, the whole concept of all the trees along the wall between the properties, they'd all die and there'd be a hole. So that doesn't work either. I just want to make clear.
Mr.
Chair,
Chair, wouldn't that be an amendment to the site plan?
It would be an amendment to the site plan, which might or might not be approved.
So whether we have the walls or not, the trees are going to remain as screening between the two properties. That won't change. The only thing that would change would be that there wouldn't be a wall necessarily built. And we understood at the time that, yes, it has to come before the board or it has to be reviewed as a separate application, but that didn't, yes, we understand that if this meets the rules of the town as far as wall heights, etc., that you can approve it and it doesn't have any effect. This approval doesn't necessarily have any effect on the neighbor, but the neighbor can come and do his own application. We understood that at the time. So we still only have this application being submitted for this site.
But am I correctly understanding that the wall is part of the application, but the wall might not be built because of some subsequent application by the neighbor?
That is correct, Mr. Block. So the joint application was really just submitted as an example for consideration of the board to show that we've been in communication with the neighbor. There is a plan in the works that would combine the two. I believe the neighbor I don't know if they're on the call or not, but there has been conversations ongoing. I believe their intent is to file their own plan at some point in time, which would
Well, let's leave that to the side. My question to you is, are we being asked to approve a plan that has a wall or doesn't have a wall? Or are we being asked to approve it whichever way it turns out the applicant wants to do it once they go forward and do the building?
Our application is a standalone application that has a retaining wall along the neighboring property line with screening in front of it, which is a change from what it previously was, which was the wall was on the property line without any screening.
Chairman, I'd like to ask the applicant's engineers the question, as there's been a lot of discussion about these walls and the overall impact to the surrounding properties when you're raising grades. Has the applicant team looked into the concept of terracing the property, whereas these walls on the property lines would not be required, especially on the, I guess it's the eastern and western sides of the property?
This is the walls that we have, the terrace walls that we show is what the applicant had asked us to prepare. It does afford them the use of their property, and that's what we prepared.
Let me ask a question.
There's such a substantial amount of fill being imported, and obviously looking at overall impacts. Obviously you have to balance use of the property with environmental impact, but it just seems that there might be a middle ground that's more appeasing to the neighbor, but that also limits the amount of fill being imported and some of the other issues that we're talking about. So
Rob, did you ever get the required plan which shows the topographical layout of this property and properties on both sides of it, as well as across the street, which is required in connection with a site plan application? Because I don't remember seeing such a thing. And one of the questions that came to my mind from that is the discussion here has always been between 1, 3, and 5, not about 7. 7 has done exactly what you have proposed. 7 has either, I don't know if it's a pool or a terrace behind its building, has a bit of a wall up to that point, and then drops down to the level. They did it in the form of a hill, but if somebody wanted a flat tennis court, it could be done other than in a hill to make it flat. And then basically terrace the place. So what you're proposing, Rob, is effectively exactly what the people next door on 7 have done. And I'm just wondering, I don't recall ever seeing the required plan with it as the topographical features of all of these properties, which would make it much more appropriate for us to even look at. I also want to make clear that there is a provision of the residential site plan review law, which is section 178 of the town code, which reads that one of the, what do they call them exactly? So I read this correctly. One of the standards that has to be followed in the review by this board is the impact of the proposal on adjacent land uses. It's the impact of noise, glare, or other features that disrupt the peace, comfort, or repose of reasonable persons of normal sensitivities residing on adjacent and neighboring. I'm adding and neighboring emphasized to make it clear it's not just adjacent. Properties shall be minimized to the extent practical, both during construction and after construction is complete. In order to do that, for the neighborhood, for the neighbors, neighboring properties, it seems that that could easily be accomplished in the terracing arrangement. Because that way the pool can be where the applicant wants the pool to be without disrupting anything much, because that's what's right next door to it. And the rest would match whatever there is across the entire street, whether it be it number 1, number 3, number 5, or number 7. It didn't go beyond that. So it would seem to me that one of the items that we're going to have to consider is exactly what I just read, whatever it is the applicant decides to do, but that the applicant's best move might be to present to us a plan which probably would be acceptable to both, to all of his neighbors or their neighbors, which terraces the property, gives him his flat land for his tennis court. It would just be a few feet below where the rest of the land is, doesn't require a load of fill, doesn't require a bunch of walls, doesn't require anything much. It will require something to retain the top part of the terrace, but that can be dealt with any way they like. So I would just propose that the applicants consider this as something that has a better chance in my mind of getting approval under the standards we're required to apply than what it is we're seeing now. I also want to make clear though, and I know I'm doing a lot of talking and I'll ask everybody else on the board who wants to, or our advisors to speak, that their timing is a requirement. 14 days prior to a meeting, documents in the appropriate numbers, in the appropriate setup must be received to be discussed at one of our meetings. Doesn't only apply to this applicant, applies to everybody else too. Is there any other member of the planning board who would like to say anything at this point? Okay, are there any of our other professional staff members who would like to say anything at this point?
I was just gonna go back to the fill issue for a moment here. Obviously, this stop work order is going to need to be addressed immediately if this is to come back before the board for its next meeting. The applicant's engineer or their consultant should plan to reach out to the building department to discuss, because the biggest issue being we don't have any information on the source of the material or its contents. we would be concerned if there's any construction demolition debris in it. So we're going to need to have enough information to be satisfied that it is an acceptable fill source if we are even to consider it to be able to remain on site.
Okay, just to be clear to everybody, it is possible that the building department would permit it to remain on site if whatever it is as to source, et cetera, is done, and which would permit us potentially to proceed in November. Is that correct?
That's correct. And ultimately, that volume of material is going to be dictated by the site plan. If the board or the applicant chooses to propose a plan that doesn't involve as much fill placement, then not all of it that's there may need to remain, but that's yet to be seen.
I can tell you, Rob, that the material is clean. It's from virgin ground that I dug from Rye, and we got an opportunity to secure those rocks, and only the material from there was trucked to the site. So obviously, this is a clean material, and I can sign an affidavit for this. And we can even test the soil if you want.
Okay, that's for the building department to determine, not for the planning board. Are there any members of the public who would like to say anything in connection with this application at this point? Okay, the two neighbors who were present at the prior public hearing, are they present or expected to be present at this one to say whatever it is they want to say?
Anybody who's in the meeting as an attendee, if you wish to speak, or if you're one of the two neighboring properties, please identify yourself if you wish to say something. I see no hands raised at this time.
Okay, Elizabeth, you hear any emails, anything, any calls?
No emails.
I have a question regarding the sign. Last meeting, before the meeting, we were alerted that the sign was not there, and it was on the ground, and we just put it in. I don't understand why we didn't get the notice the same way that we got it last time.
It may well be that it was noticed not being there today.
So we would, according to Elliot, and Elliot can also sign an affidavit for this, that he or his people put the sign in, and it might have been even taken. There is a construction next door. They could have been removed by the construction people, or people that are driving by there, and they take signs. I mean, obviously, sometimes you have that happened last meeting. I mean, the sign was there. So
well, it's a moot point for tonight because the public hearing is not going to be closed. But what you can do for next month is, why don't you take pictures? You know, the applicants are living there, so take pictures of the signs that they're up, and know that sometime a few days before the meeting that there will be a drive-by for site visits. So just, you know, make an effort to see if the sign has fallen down, and on the slim chance that it's down again, take a photo, show it. And, you know.
But I'm just concerned about the ZIFs. They went through hell with this application. Not only that, now they're in the hospital. Ami is in surgery, and it's another month delay for them. They have 2 young kids, and obviously it's they're living in a small apartment, and obviously. You know, they're carrying two houses. I mean, one rental and one house, and it's not fair for them to hang this on a sign that was there, and might have been taken by somebody. Maybe maybe it was taken and they simply, it's another month for them to wait and not to get their dream house. This is why they moved to the suburbs. And obviously, they're a little bit upset now.
Let me just say, Lisa, you want to?
There's 3 reasons the public hearing can't be closed tonight. The first is that it was observed by 2 people independently that there was no posted sign. The second is that a stop work order has been issued. And the third reason is that the standalone modified site plan was not properly submitted. So let's not dwell on any one of those. Let's just move forward and hope that at the November meeting, you can get the result that you're looking for.
If I may, I just have some questions for clarification because there was a lot that the chairman put out there. So as far as delivering proper instruction to the project team, if I heard you correct, Mr. Chair, you're looking for a topographical plan of 1, 3, and 5, 1, 3, 5, and 7 Cornell?
Well, actually, it has, if I don't want to, it's all in the code. So since you're an attorney, you can look at the code and see exactly what's required, but it's adjacent properties, which would be 3, 5, and 7. And I believe also the properties across the street. I didn't look at it today.
Because the original submission did include the area map of showing topo of all the properties. We didn't resubmit for this application because it didn't change. So that was part of the original application that was deemed complete. The only thing that you had that was missing out of the original application was the certified deed that we subsequently submitted.
Yeah,
so that is there.
Okay, let me just say this.
Just to give some guidance on the topographic issue. So Mr. Senor is correct that the initial submittal did include area maps, which include topography from the Westchester County Department of Planning for the whole neighborhood. I would say that is a fairly standard practice for residential site plans. The requirement for detailed topography, which is generally based upon a survey, is a little bit more of a discretionary call, in the judgment of engineering, in the view that, this property has walls that will directly abut the property line. Having some extended topography over those property lines is arguably important on this application. So I wouldn't say that, that we need to get a detailed survey for the entire, block, but if the walls are to remain, that is, reasonable.
Our topo does go into the neighboring property at least 10 feet or approximately 10 feet. We don't have permission necessarily to trespass to do anything more than that. Are you asking for something more than that?
I think that the board needs to have the level of detail to assess the impact to the neighboring properties. In this case, if the walls are pulled back, and I don't know, Elliot, if you're able to maybe give them a more detailed version that incorporates some county GIS data on your map, that might be sufficient. They just need to have the level of detail.
Look at the checklist on which items 8 and 9 were checked. They specify exactly what the topographical map is supposed to specify or include. And since it's checked, that must be what you thought you were presenting. But I'll leave it to Rob to decide whether or not you in fact did so.
Okay.
And we produce these checklists and so on for a very specific reason, so that every applicant is treated alike and so that every applicant gets to see exactly what the rules are. Mr. Napier, anything?
No, I think I can work with Elliot and Ilon from there. We can take a look at the wall location. We'll have further communications with the neighbor. We'll be in touch with the building department to address the stop work order and the potential resolution of that violation. And we'll be back to hopefully be in front of you in November.
Okay, we will plan on your being here, but unless everything has been resolved as set forth by Lisa a few minutes ago, we will not be able to continue except in the same form we are now, meaning we can continue the public hearing we can't close the public hearing and vote.
Understood. We will, we'll certainly take care of the notice to make sure that's a non-issue. And the biggest impediment I see at this point in time is the stop work order. We'll have to address that with the building department so that we're not wasting everyone's time. And I hope to be able to achieve that and be back to you for your meeting in November.
Okay, let me, one more last thing, and that is that if the neighbors who've been involved with this and are most involved, which are the people at 1, 3, and 7, are all in favor of this, it would be nice to get something from them for them to appear or get something in writing saying they are.
There has been, I personally haven't been involved in the communications with the neighbors, but I do understand from speaking to our team, there has been an open line of communication there. And so I believe their lack of attendance at the meeting here tonight may be a sign of their non-objection, but we'll continue to have those conversations.
Thank you. Okay, since we can't close the hearing, we'll adjourn the hearing until the November 11th meeting. Thank you all.
Thank you.
Okay, next item is 127 Garden Road East, which is on for consideration.
Okay, I promoted the applicant's engineer, I believe they're architect. Benny or Frank, if you can hear us, is there anybody
Yes.
else who may be joining us?
I just think Frank and myself will be on tonight.
Okay. Thank you.
May I proceed, Mr. Chairman?
Sure.
Thank you. Good evening, everyone. Benedict Salanitro for the application for 127 East Garden Road. And Frank Marcella is, there he goes. Hi, Frank. Is here as well. He's the architect for the application. Allow to share screen. Here we go. So what I'm going to do is just take you quickly through the plans that we've submitted. On this application, we met with the town staff at our first peer review meeting just about 3 months ago. July 24th, we met and we had subsequent conversations. So the plans have gone through a few iterations and changes. And we did receive a few days ago additional commentary, which we will be getting back with some additional changes based on those comments. I'm just going to take a quick drive through, if you will, with Google Earth, just to give everyone some clarity on where the house is located. It's on East Garden Road. The proposal here is to demolish the existing home and to construct a new single-family residence. As you can see, we have a very mature tree that is a specimen tree, which we are taking every precaution to keep on the site after the new home is built. So the existing driveway, which is down to the left side of the property, as you face the property, is being proposed to come on the right side. There is a town tree that we will be making a request for its removal. But what was important about, wanted to just share with the board the interesting part of the landscape or the treescape, public treescape in the neighborhood. This is a relatively newly planted tree. It was planted under the wires. And besides this tree coming up, that's really the only other tree in the village right of way, town right of way on this within the general area. There are no other street trees, but But as you can see, trees on the wires don't really get much survivability after being butchered. This tree actually has already started growing in. So we're making an application to have this tree removed. We will obviously replant trees in the right of way should the town desire, or provide a donation to the town's tree fund if that's appropriate as well. But the proposal right now is to have that as the new proposed driveway. I'm scanning through, Frank, I'm scanning through the drawings that we can get the details should the board desire. But since this is a consideration hearing, we were hopeful that we can get to the Coastal Zone Commission meeting, I think it's October 26th, and then obviously get into more details relative to what's being proposed. So let me just take you, this is an aerial view of the parcel in question, and our perspective composite photometrics of what the new house is proposed to look like from the street views. This is site plan that the red dotted line is the existing house. Again, the driveway is tight to the left side of the property, the west side of the property, and the proposal is to come in on a more level portion of the property on the easterly side. As far as we have floor plans, roof plans, elevation views prepared. We have prepared an engineering plan. The proposal, the property slopes in the rear away from the house. The neighbor to the east currently has a retaining wall. The property does slope both in the northern and westerly direction. The applicant is proposing to level or create a more level rear yard, usable rear yard by installing unilock retaining walls so that can be achieved. Some staff comments on that, and again, we'll be prepared for the public hearing to discuss those in more detail. But the essence of the regrading will be in the rear of the property. And what else do I have to share? Just a quick note about impervious areas. We're going from approximately 3,200 square feet of existing to 4,272 square feet. So in the totality of things, there is a net increase of impervious area of 1,000, just under 1,100 square feet. We are proposing to capture the 4,200 square feet of impervious surfaces in stormwater detention facilities on site. We did prepare or have prepared a landscape plan to show some tree replacement and tree planting and other landscaping measures as well. That's pretty much it, Frank. Unless the board has any questions, we can take the time to go through any questions you may have. But the essence here is we're removing the existing structure, proposing to construct a new single-family dwelling in its place.
And at its greatest height, how high do you anticipate increasing the level of the backyard?
Oh, I'm sorry. Yeah, that should be shown right.
You may have noticed that's relevant these days.
Yeah, so we have approximately at the greatest height, which will be the retaining wall where the wall is, it's approximately three feet on the wall. Let me just zoom in if you don't mind, get more accurate information. 3 feet, 4 feet at the corner, 2, 3 feet, a little over 3 feet. So it looks like there's an average of 3 feet or less along the side. And it's 2.5 feet, obviously 0 here or 1 foot. Again, this is an existing retaining wall on the neighbor's property, proposed retaining wall. 4 feet on the side. There's an awkward drop off here along the westerly property line. If you guys, if any member goes to the site, you'll see on existing topography, it's pretty flat here, but then there's just a roll of this of the land along that property line. So this is just to flatten this area out and take that dip out. That's what that'll be for. It'll be more, it's clearer. I don't know if we have any pictures, but it would be clearer to see that, on site. We do have some photos of the land. Let's see if I can share that with you. So that's the neighbor on the right. We want to go to the rear. It's hard to see on this photograph. This is the photograph right here. So this actually, you could probably see because there's a little shade here, but you can see the property just takes a nosedive pretty severely here. And it's actually even a little difficult to walk on. So the retaining wall is just to create this area to make it level and get rid of this dip. We think that leveling this off obviously will help with stormwater runoff onto the neighbor's property. There's a fence line here as well. So making that area flatter should help that runoff and ponding of water along the edge by eliminating that. So that's the reason why the wall is along the side here, because there is that variation.
Kenny, what is the neighbor going to be seeing when you put up the 3-foot wall?
There is, it's very densely vegetated in its current state. They should not see anything along the westerly side at all. On the easterly side or the rear yard, on the northerly end, which is the direct rear, there's heavy vegetation, understory growth as well. To the west, it'll match for all intents and purposes the existing wall that's there already. Let me just take a look here. Yeah, so there's an existing wall here that's 3 feet. Rather than, we could have utilized, but obviously since it's not the wall is not on this property, there would be another wall built in front of it with a space in between. Ideally, folks would backfill against that wall to achieve the same gradient. This property appears to have been modified in elevation as well. So you can see from the photos and that there's ample vegetation, and we don't, especially on the westerly side, there's a tall privet hedge screening that will remain in place.
As far as drainage is concerned, you're going to improve the drainage when you do the leveling. What about the rest of the property?
So there's two parts. Obviously, we have to make sure that, as one of the comments from staff, that the retaining wall, the drainage for the retaining wall is properly mitigated, ensure that we're not creating any negative impacts to the neighbors, which we don't believe we will, because the wall basically, will act to just basically hold the soil. The rest of the property, in terms of the house and driveway, will have downspouts leading to a subsurface drainage system. I don't mean to go as quickly as I'm going, but I just want to get to the answer. So we have a number of dry wells. It should be 6. 5 are shown here. We have to get some further detail to answer some questions that we got from staff. So the intent is to have drainage in the rear. This is the 48-inch white oak that we are protecting. So we're not doing anything here at all. We want to keep that tree protected. So there's no grade changing or anything. All the grade changing is in the shaded area with some slight here.
And you're capturing for a 30-year?
The 25-year storm is being designed for, and 4,272 square feet of impervious area is being calculated in the design.
Thank
And
you.
just a minor comment to add. I'm not sure if it was on Anthony's memo, but we have been asking that for tree protection to be shown to scale. Right now, the plan just has a traditional box around the tree, but if you could show that based upon the actual EVH, show that to scale.
Sure.
Bob, you have the topo type map we were speaking about before in connection with this property?
Yeah, we do have tail lines going on to the neighboring properties, Mr. Chairman. You can see that they are going and extending within 10 feet of the adjoining property.
Okay, yeah, there they are. I'm sorry.
Yeah, I'm going to just make it more clear. You can see that this is
Yeah, now I can see them.
outside the property limits.
And your wall will be natural stone?
We're proposing to utilize a unilock wall because we want it to be less pervious. And we have an inside drain as well. So the unilock walls are the pre-engineered concrete block walls that are colored, etc. They are less apt to wick water through, but we do have gravel backing, and we also have a drain proposed behind that wall right here.
Okay, there it is.
The neighbor's wall side, if you will. This is the property line, 8-inch offset. The walls have a slight taper to them, just the way they get stacked up. Clean fill with some gravel backfill, and we're showing a drain. But there are some questions that staff has asked me to look at, and we will be looking at that as well.
Do you anticipate any rock removal?
Yes, but it doesn't matter because we're not allowed to do any rock removal. There is a potential for rock removal towards the rear. There is a full basement in the current house. So as far as the outline goes, the garage is on grade, so there'll be no excavation there. The only additional excavation, if you follow the mouse here, is going to be in this area here. Everything else is free and clear. As a matter of fact, the way the driveway is coming in this way, it's actually the garage is under the house. So this is already excavated. If there's going to be any rock removal, we anticipate it to be in this area right here. But we did a test pit here. We went down 6+ feet and we did not hit any rock. So we think that we should get lucky. But we do understand and appreciate that the town board has set a moratorium on rock removal. But here we are in the month of October. We hope that if we're engaged in any kind of work and construction, it'll be in the new calendar year, whatever new regulations will be imposed.
Anybody have any further questions?
I was just going to add with regard to the rock removal. Obviously, as it's been pointed out, the moratorium is currently in place, but it would probably be a wise decision to still contemplate the quantity and the impact of rock removal as part of the future plan submittals, just so that if the moratorium is lifted, that it becomes part of the site plan, and that work could proceed without having to go back for an amendment.
So I have a placeholder for that I have to still fill in, Rob. It's on ER2. I just have to fill in the numbers and do some work with the property owner. So that is, I've used this on all my drawings with the anticipation of, if there's going to be an anticipation of rock removal, that I'll quantify that. So this is a placeholder right now for that to be filled in.
Very good, thank you.
Thank you.
Any further questions from any board member or member of our professional staff at this point?
And the only thing I'll just add, one of the concerns was with the walls, they seem to be close to the tree drip line in the back around several existing trees. So I'm just not sure, that's viable. And in terms of the drainage from the walls, just seeing that that's going to work. It's called out that the perforated pipe is to drain back to the drywall system. So we just want to make sure those elevations work, and that perforated pipe should be set as low as possible to capture any seepage from the walls. Otherwise, the walls maybe should be pulled back a little bit and something done in front of the walls so we don't get a drainage issue on any adjoining property.
So, yeah, this detail was modified in consideration of the elevation of the proposed drainage structures. Typically, we would have that at the footing line or at the lower line below the adjoining grade. I was mindful of the fact that that would not drain by gravity. So that's why this is raised up, because of that consideration. So
But at the same time, I think, I believe one of my comments was that your drywalls are all in fill.
Partially, not all. They're not in
partially. Okay, so that if you do a cross section through you, that'll kind of clarify that.
Okay,
we'll be able to see that better.
Yes. Okay. Yeah.
But if you got 6 feet on a test pit, it's possible you can go a little lower on those.
Yes. That is one of your comments. Yes.
Yep.
Item number 3.
Yep, there it is.
And 4.
Okay, thank you.
But another perspective on the wall drainage. Benny, if that wall is a block wall system that has weak joints, you might not need the heel drain system at all. So just as another option if it's infeasible to bring that back into the Coltex.
Say that again, Rob. I missed that.
No, I was just offering that if the wall is a modular block system that's going to have weep slots in between the blocks that could let drainage pass through, you may not need to put in a heel drain pipe to alleviate the hydrostatic pressure.
Yeah. So you mean the modular modular wall different than this type of a modular wall?
I mean, it could be. I'm not sure what your plan calls out for the manufactured block, but I've seen several that actually have like openings between that actually let water pass through. So just if you happen to check the specs, maybe they offer that as one of their installation details.
Okay.
And when we've
I'm
done
not sure
that,
if Unilock does it.
When we've done that, when we've allowed the water, especially in a fill condition like this, to come through the walls, usually, and you've done it before, put something in
swale
front
here at the bottom,
so that we don't end up with water on other properties.
Yeah.
So that's just something, go one way or the other. If you do the drain behind the wall, it's got to be low enough to capture everything. So that's just got to be looked at a little more carefully.
Yeah, we were going to go with the traditional dry stack wall, but that has a tendency to have a greater probability of lateral seepage of water. The Unilock walls have been more successful to not have that problem, but we'll look at that. I appreciate that comment.
And just, check your grades, because I think at that back corner, I think you're closer to 5 feet on the wall height. If you look at the existing topo in your back west corner.
Okay.
Yeah, so that was a question too. The grades get a little tight on that.
I'm going to look
side, and just how that's all graded.
Yeah, the existing grade, like I was trying to explain before, there's that the sharp decline here. Some, like a slope that this may have been. This may not be native to the site. Maybe they brought in material at one point and then they just rolled it out. So there is an awkward steepness to this one little corner here. So you might be right about that.
Yeah, so if you see in that corner, you've got a contour of 58 existing.
Yeah.
and-
Yep.
But you're calling that bottom of wall of 59, so you
Yeah,
really might be a foot higher there.
Yeah, it's not gonna float in thin air. I'll take a look at that.
Thank you.
How far do these walls extend above the surface of the ground that's filled in?
Oh, I went through that. So, Mr. Chairman, the average is 3 feet. We show 4 feet. They can't exceed 5 feet by the zoning code.
Right.
So the maximum permissive height would be 5. It goes from 1 foot down. Beginning is about 1 foot to 2, 2.5. 3 is the rear is about 3 on average. We got a little dip in this corner here that might be in the 5 foot range. We'll see what we have to do there. Maybe I'll just leave that alone and cut this corner out. I'll look at that. So this corner right here is the highest wall, but only for maybe 5 feet in either direction, 5 to 10 feet here. So then everything else is in the 3.5 to 4 foot range.
But that is measured from the neighbor's property or measured from his property?
The neighbor's property.
Okay, so how high is it on this property so that nobody, some kid doesn't fall off it?
So again, it's the height of the wall doesn't change. It's a matter of perspective on where you're standing.
No, I understand that. But if a kid is playing on the new raised backyard,
right,
and at the end of that yard is a 4 or 5 foot drop, what
right.
stops the kid from falling over?
So there's evergreen plantings that'll be planted there, and typically what they'll do is they'll put some chicken wire back there. I don't know if he's showing that here or not. We can't put a fence on top of the wall because then it exceeds the overall height on the zoning. The town's code looks at the wall and the fence as a single unit. So we don't get the opportunity to go with a 5 foot wall plus a 5 foot fence. So it's a maximum height of 5 feet or a step back. So
I understand what you're saying, but if I look at this, which is, I think, the landscape drawing, right?
Yeah.
In the left rear area, there does not appear to be anything to protect somebody from going over the edge of the fence.
Yeah, so I mean, it's no different than what exists right now. I mean, we have, and I don't think there is a code requirement for fall protection off a wall. Let me just see here. I want to share that picture that I show. Yeah, so right here, how do I get this to? What happens to my zoom option? So this wall right here. The same concept, if the neighbor is standing on top of the wall, they can fall into this property. So not all walls have fall protection. As a matter of fact, if you drive throughout the town, even on town features, themselves, town features don't have walls. Here we have a wall in the driveway with some interior steps to that wall, no fencing or railing protection. So it's not uncommon to not have fall protection. I mean, that's a building code. If the building inspector feels that you need it, then obviously we would look at that. These kind of comments go back and forth. A lot of municipal ponds and lakes and open water courses that have walls don't have fences on top of them. So it's a rule, or I can't give you the answer you're looking for, but we're not proposing to put a fence on top of the wall.
Okay, but if you take the photo you showed, the left elevation, number 11, which shows a wall, 2 walls,
Yes.
one on each side of the garage.
Mm-hmm.
Neither of those walls is anywhere near 5 feet tall. And it's a matter of, providing a level of protection, which can be done, as you suggested, with landscaping as opposed to putting a wall up there.
Correct.
It seemed to me that some dense landscaping that would stop a kid from going there would be appropriate.
Yeah, no, I don't disagree. I don't know if there's a magic number where we say anything over 3 feet should have some type of fall protection, either in the form of dense vegetation or some other measure. We would definitely be looking at that. Traditionally, 3 feet is where we would not worry about fall protection.
Right.
But I'm gonna look at that corner that Anthony was talking about to see how high it actually will be and whether we would terrace that or keep it lower. But just to clarify, and unfortunately, I don't have the photo, but this is the only photo that I can share, number 14, that there is very, very tall vegetation along that westerly run. And this photograph doesn't go take it to the corner, but the vegetation, the existing vegetation will still be taller, much taller than any proposed wall that we are proposing. Frank, do we have a picture hanging around for that left corner?
I'm sorry, I don't see one.
Yeah.
But that hedge is.
You and I looked at that because that's one of the things that we were considering when we met with Rob Beresford, who's putting the plan together, that the neighbors would not be seeing that those walls anyway.
No, I'm not, again, I'm just talking about a safety issue.
Understood.
And, you know, I think it would be nice if the landscaping were increased, I guess is the right word, to protect that area, because kids do the darndest things, as you know.
Amen. I do know.
I had a question just about whether or not the fill in the rear yard was really necessary, because I kind of recall it being fairly level throughout the side and the rear yard there.
It's not as level. I mean, it's there is, you know, you can see from the topography that I'm showing, you know, the property slopes from south to west. That's the drainage pattern. Okay. And then obviously across this way. With the elevation of the current deck that's out there in the rear, let me show you that. I think we have existing rear elevation. We're trying to minimize the walkout. Did I miss it, Frank?
Yeah, you do have a rear shot.
Here we go. So you can see how high that is. So the current rear elevation, the reason, one of the, you know, so because the property does slope, you're walking in the front door, let's say with 1 or 2 steps, and you're walking out the back door with, you know, 5 or 6 steps. We wanted to minimize that elevation change. That's why that's one of the reasons why it's being proposed. It's not as level as you think, because from front to back on the topography, I think it's a 4-foot difference from front to back. Take a look at that.
Yeah, it's been a while since I've been there, so.
Yeah. 2, 4, 6. Yeah, it does slope down.
Yeah, it's about 6 feet.
That anyway, because we have to answer the questions that Anthony has asked us to look at. So we'll be looking at that as well.
Right. Yeah, I'm really not that crazy about the tree wells either. I think the trees end up just not doing well in those situations.
Yeah. So what we did was we tried to follow. Not that, you know, 2 wrongs don't make it right, but we tried to mimic the current condition along the easterly line, where the current wall on the neighbor's property does have tree wells around, you know, some of these trees that are on their property, and even on here. We went just tried to go a little wider. Yeah, I mean, I don't, I'll have you know, I can't speak to that. Whether the trees would be impacted negatively by tree wells versus some other means.
Mm-hmm.
The protection of the tree in the front is out to the drip line, because it looks pretty small.
Yeah, that's what Rob mentioned, that I should draw it to scale. So this, you know, will probably most likely have a much more substantial box around it. I would think that it would be something like this.
Yeah, it'd be a lot bigger, I think.
Yeah, I'm
The
sorry.
coastal zone will look at all that anyway.
Yeah,
You can make a circle too.
I can make. Yeah, so we'll definitely, you know, change that. No, doesn't want to get out. Yeah, so the tree is, you know, rather substantial. I don't know why I'm having problems with this. So we would be looking to we'll modify the view on that.
Okay, is there anybody else on the board or the professional staff who has any comment, question, other than to suggest that we send this to coastal zone? And Liz, we can get to the October coastal zone meeting still?
Yes, I was just looking, the submissions are due on Monday, October 19th. And the meeting is on the 26th.
So they can make the meeting?
Yes.
Okay. So anybody want to make a motion that this matter be sent to coastal zone?
Well, I don't think you need to make a motion to send it to coastal zone, but you may
just do it?
decide to make a motion to set a public hearing for the November meeting.
Right.
Yeah,
I was gonna say.
Okay, so well, actually, yeah, if you make the October coastal zone thing, we could get it on for November. Anybody want to make a
That would be
motion to
great.
put this on for the November public hearing on November 11th?
So moved. Whoops, sorry.
Second. All in favor?
Aye.
All opposed? Abstentions? So be it. Next.
So we're next. I'd like to go right to the videotape if that's okay.
Okay. So are you also handling 46 Villa?
Yes, sir.
Developer.
Same guy.
Yep. Thought so, but I figured I ought to ask.
So we have similar, but this is a smaller parcel. This is 46 Villa. Again, Frank, Marcel, and myself, Robert Beresford is working on a landscaping plan. Objectives here, we'll go through the plans, but just want to get a Google Earth view. A few years ago, this new home was built next to it. So the objective is to have this house removed with a newer dwelling in its place. Let me see what I got here. Okay. The existing retaining wall, I just want to bring that. So the folks here with the new home, they constructed a new retaining wall on the property line. The existing house has a retaining wall. It's overgrown. The proposal is to leave it to the point where a modification of the driveway width is being proposed. So I just want to share that visual. We can go to it as well. So this is the home elevates, or the property elevates from the street to the rear. And this is the aerial view of the project site. So the proposal would be in this composite rendering would be to have a house sitting in this plane here with the walls that as shown. The existing house is in the dotted range. The new house footprint is pretty close to the existing. As a matter of fact, the existing house is further, is non-zoning compliant. So the new house will be moved in to meet the minimum setback requirements on the side yard. Basically similar footprint, obviously different bulk for the proposal. We have, I got some placeholders on my plan for drainage, and we did receive comments from the staff. We did have a peer review meeting in September. So this is a newer more, information that still needs to be provided for. So existing house that is being removed, existing driveway, and then the proposed house and new driveway. So the driveway currently is single car. This is double with a 20-foot maximum zoning compliant driveway width. And in doing so, and widening the wall that I was referencing before, would be trimmed back, and then the radius would be created so that the wall would be in keeping. So as far as numbers go, the existing impervious areas are 2,700 square feet. The proposed impervious is roughly 29, just under 3,000 square feet. So this project site, is proposing an increase of just over 220 square feet of impervious area. The driveway and the patio are proposed to be of pervious pavers, so as to reduce the amount of impervious surfaces. It's relatively straightforward, but the question here is how much rock do we have to remove? The house does have a full basement, but there is areas that we expect to have rock removal. We did calculate that at about 160 cubic yards of rock removal for this. And looking at the project next door, they had some rock that was removed as well. The property next door is larger. So this house is modest in size given the square footage of the parcel. So we have some drainage in front and rear. We have a discussion point about how we want to overflow or manage the stormwater by connecting to a town storm drain in the street. We'll be looking at that option as well. Yeah, and again, the drawings were submitted, with the architectural in mind. So from the rear, just to give you a perspective in terms of elevation, you can see that the rear would be walking out of the first floor, and this is the traditional walk-in garage, and then walk out the first floor to the rear. So that's your grade elevation changes, and this is the cut through of the property, so you can see that everything slopes down towards the street. And then obviously the properties continue to go climb up as you leave the property. We still have, we haven't excavated test pits here yet. Again, these are placeholders for, to be completed and to be evaluated further. But for the purposes of the application, it is for the removal of existing structure and the installation and the construction of a new home. I can answer any questions. I think, Anthony, you did have some comments.
So I have a scheduling question.
Yeah.
Elizabeth, again, when is the coastal zone meeting?
26th of October.
Okay, so Benny, if you're going to potentially be making some significant modifications and get them in 14 days before the 11th of November, pretty tough.
Well, no, I wouldn't call them significant. We need to provide drainage. We're proposing to utilize subsurface detention systems, like Coltex or dry wells of sort. The question becomes whether I do not at this point show anything leaving the site as far as overflow into the town property. One of the comments is to consider doing that. That is to me, I call it a miscellaneous item. That's a consideration for the drainage. But one of the things about that is, so we have an existing retaining wall. We're showing some drainage in the front and in the back. But as far as the front goes, the sidewalk is in good shape. We have a utility pole. We have a hydrant. So coming down through here, we would probably, the only, short of going into the street to make the connection, which I see, there might be some interferences, we would look to go in front of the stone wall, which is on the town property line, and then come through the back. So we have investigated that as an option. It is a benefit to have an overflow into the town system, so that it doesn't back up onto the property, onto the neighbor's property. But so that's not a significant change. That's a consideration, which we will probably look at that. But Ralph, just to give you sort of a point of view here, you can see the height of this wall is more than 4 feet. Same thing. What kids do, they'll walk down and then they got to figure out a way to get down. So just an example where walls don't necessarily have railings on them.
But if you look at the front wall, it has vegetation all over it.
This one does.
Effectively,
yes.
It has a wall consisting of landscaping.
Yes, the existing, yeah. That's all that get cleaned up. That's all overgrowth. But just
That's all I think by the looks of it. But yeah,
it is, yeah. So anyway. So it's a tall structure there right now, and I think, Frank, correct me if I'm wrong, I think we would be at or lower as far as the ridges go. The new house would not be any higher than the ridge of the existing house, right?
That's correct, yeah. We're basically, schematically, the house will work very similar to the existing house with the garage placement and the front door placement. And the approximate first floor elevation are very similar location to that existing structure, but we are not as tall.
There you have it, right, Frank?
Yeah, that's the 3D rendering to scale.
okay, does anybody on the board or on our professional staff have any questions?
Just one, Benny, you said you hadn't done the perk tests as of yet?
We have not done the deep test pit. We did a perk test. We didn't do the deep test pit to determine the depth of rock. Do I have that? No, I didn't have it. Do I claim to have it? I don't think I did it. I know I didn't do it.
All right, well, one of my, probably my biggest concern here was just the proximity of the dry wells in the front to the wall.
Yes.
It just seems very close. It's going to seep through the wall or through your weep holes.
Yeah, I saw that right here.
And, I'm a proponent of, if you can do an overflow, do it. Probably the best path there would be to go actually in the road in front of the curb and run the pipe down and right into the side of the catch basin, unless there's a pipe there. But I don't know, that's something you should consider. But I think,
yeah, this dry well, this catch basin actually, was installed as part of the house project here. So we Rob, thank you for those plans, by the way. So the engineering department, Rob Wasp, was able to share that. So as part of this project for this home, they installed this catch basin here, and they tied into the catch basin opposite across the street.
Okay, yeah.
So this house.
I mean, it wouldn't take much to run like a 4 or 6 inch pipe in there, even in the grass area in front of the wall. You probably
he's thinking about the grass area.
Yeah.
People might get finicky when they see, their lawn disturbed.
Well, it's not their lawn.
I understand that. I said people get finicky. Regardless of whether it's theirs or not, they still get finicky. So
I don't have to deal with that. Rob will have to hear from them.
Yeah, we're not looking to engage in controversy. So definitely, we would want that opportunity to tie in as the overflow with a 4-inch or 6-inch pipe. So we'll be looking at that as well. So, Mr. Chairman, if we are not suitably modified and prepared to come, we will just adjourn the meeting. But it'd be nice to know that we have an opportunity to come and present at a public hearing in November, if that's possible.
So does anybody have any other questions or comments, or can we have a motion to set a public hearing for November 11, which will be adjourned if necessary? Anybody around?
So move.
Second? I hear nobody. Somebody second the motion?
I seconded the motion.
Thank you. All in favor, please raise hands.
Aye.
Opposed? Abstain? Done. Thank you.
Have a wonderful evening, everyone. Thank you for your time and patience.
Pleasure. Thank you.
Thank you.
Okay, Rob, will you bring in the rest of the world, please?
Will do.
Did we refer, I'm sorry if I spaced out. Did we refer this to coastal zone?
Oh, I'm sorry, skip that, but yes,
Okay,
since that didn't take a vote, I apparently can just do that.
right. And so Liz, I'm sure Benny heard what the submission deadlines are the same as Garden Road, so.
Right, yeah, we'll talk before the submission comes in.
Okay, good evening and welcome, David Kenny and team. David, I promoted some people who are still in attendees. Can you confirm if there's anybody else still left in the attendees group?
I don't know. Can I see the attendee group?
Okay, no, I see one more, Klaus Wilmer.
Thank you. See, it looks like we have everybody.
Okay, very good.
Looks familiar. Okay, David, you want to commence things?
Absolutely. Again, for the record, my name is David Kenny. I'm an attorney with Snyder & Snyder, representing the applicants Homeland Towers and Verizon Wireless for their application to construct a wireless telecommunications facility at 808 Weaver Street, also known as the Bonnie Byer Golf Course. Since our last meeting, we've made a responsive submission to comments we received from the town's environmental planner and the other town comments we received. In that responsive submission, we did provide the line of sight profiles from the Sheldrake Environmental Center that the board had requested. I'm going to share the screen and show those now. Matt, if you could go through what we're reviewing with the with these line of sight profiles.
Sure. This is Matt Allen with Saratoga Associates representing the applicant. At the last meeting, we were requested to prepare these line of sight profiles to give a better understanding of the existing lay of the land and vegetation from various locations within the Sheldrake Environmental Center and the Johnson Conservation Area or Larchmont Environmental Area. There's several names. I can't exactly remember what's on the sign outside, but it's the property right behind. I'm sorry?
It's a long name. We know what you mean.
Yeah, I think I'll call it the Johnson Environmental Center, but I think you understand what I mean. So what I did is I cut line of sight profiles. I believe, let me see, there's 1, 2, 3, 4, 5, 6, 7, 8 of them. 6 of them were cut from locations that we had already taken photographs from that are in the visual assessment report. So the VP or viewpoint numbers correspond to the photographs that are in the visual assessment. So you can see exactly what the view is from those locations. As I said, we did 6 that matched up with photographs. There are 2 additional locations where we did not take photographs, but I added them just for additional information from places that we did not visit during our field work during the balloon test. However, I thought they might be of interest to the board, so I added them. And those are the locations that have an A after the number. So you will not find a photograph for 13A or 10A, but they are from trail locations, so I thought it would be of interest to include them. What these show is that from just about all the locations, there's substantial vegetation in between the studied viewpoint and the proposed tower. That vegetation has different levels of effectiveness as far as screening. All of them will be virtually 100% barriers during leaf on season. During leaf off season, there'll be some degree of visual penetration, and that is labeled. The degree of visual penetration was determined from the photographs that were taken from that same location during the balloon test that was done during the leaf off condition. So the line of sight gives you an idea of distance and the level of visibility that may occur. So I'll leave it to the board to ask questions from there.
Actually, I thank you for doing this, but I think what they show is something that we mentioned before. And that is that the so-called branches of the tree, let's call it a tree, start above where the line of sight hits. So that, to me, enforces the concept, that's the right word, of starting the branches lower, so that the green ties into the green below it. I mean, there's a wall of evergreen trees. What kind they are, Elizabeth can tell me, but I don't know. And it would seem to me that I'll take the bottom picture right here. Green ought to tie into green. It's easy enough to do by just starting the branches lower. Besides, I mean, I believe the branches are designed to start at 50 feet. We don't have any trees around here that don't have any branches for 50 feet. So is there any reason why the branches cannot start at a point where, following your line drawings, everything's green that people see?
Matt, can you explain, I think the question about the branch height is related to where you can see the actual tower from. And I think your line of sight profiles do a good job of showing how the vegetation from where you're looking at is actually closer to you, not right next to the tower. So the tree height right next to the tower is not as relevant to where people will be seeing this through existing vegetation. Can you discuss how the line of sight profiles show that?
Yes, and you're correct, David. It's important to remember that from the conservation area, there is no location with a direct view to those screening pines that are directly adjacent to the tower. All views look through existing dense woodland. So during leaf-on season, that view to the lower portion of the tower really becomes moot because of the full foliage of the vegetation that's within the conservation center and supplemented by vegetation between Weaver Street and the golf course. So views during the winter are virtually or during the summer are virtually non-existent. So what we're really talking about are views during leaf off season. You're really starting a few weeks from now in early November through April, where you would have a filter view from some of these locations. Other locations, the existing vegetation is so dense that there would be virtually no view of the tower anyway. But there are no locations except for on the golf course itself where there's an opportunity to view the lower portion of the tower unencumbered by existing vegetation.
But what you just said, if I understood it correctly, is that for 6 months of the year, it will be visible because for 6 months of the year, we have no leaves. And all I'm saying is, why can the branches of the quote tree not start lower so that one does not see the quote trunk of this tree and simply sees green extending over evergreens? So no matter whether it's leaf on or leaf off, all you see is green.
We can look into that, but I think the answer is that we're providing is that in the line of sight profiles, we're showing that the existing vegetation that's off of the golf course would screen most of these views. And it is part of our visual analysis, which again included the photo simulations from these areas, which I'm going to show now. And again, I believe those photo simulations adequately demonstrate that all views of this facility from surrounding public access areas are going to be screen views from the vegetation. Even in leaf off conditions, there's still going to be trees that someone would have to look through. And the reason we don't want to just lower the branches all the way is it may affect the structural capacity of the tower and affect its ability for co-location. We can look into that, but I believe we've demonstrated in the photo simulations we provided that there are no views of the facility that wouldn't be through trees. And again, the balloon float and the balloon test was done in leaf off condition. So the photos that we provided show what it would look like in leaf off condition. And I think our photo simulations adequately demonstrate that there's no direct views of the facility and that the bottom branches are not visible in any of the photo simulations or any of the photos that we've shown.
Well, let me just get to your, since you led into it, the visual resource assessment. Let me ask the members of this board, which of you, if any, were invited to view the red balloon test?
Not me.
I wasn't. Was anybody?
No.
Okay, because if you read the visual resource assessment, it talks differently. And it makes it
We did
clear.
have a meeting with the town at a pre-application meeting. Mr. Wasp, could you please express that we did have this meeting and we discussed the balloon test?
What?
Yes, I can comment on that. That Mr. Kenny is correct. That it was that we were given advance notice of the balloon test, and I have to find it on my computer, but I do believe that an email was sent out, but nonetheless, they'll have to be confirmed.
What the report says is the photographs were taken from sensitive visual resources that were identified and mapped in advance of the field view visit in consultation with the Town of Mamaroneck Planning Board. That did not take place. What took place is exactly what you said took place. There were peer meetings, which Rob was at, which worked out that we had issues with views from various areas, including the Larchmont Reservoir and the various town properties. But the rest of what this says, there's actually a whole bunch of stuff in here that isn't quite accurate. But we never had a chance, we being the members of the board, to view this balloon in place from the places in question. And some of the photographs that were taken were, I would say, carefully taken in areas where, as you pointed out, there were a lot of trees to block the view. But if you look at the same photograph and you go 10 or 15 feet to the left or right, there are not a lot of trees to block the view. So it matters. And it matters, the ones in question, as I see it, are primarily those with the Larchmont Reservoir. And let me call it that. So my understanding is that there has been a discussion or a proposal on the developer's part to make a contribution to the tree fund of the Town of Mamaroneck so that the town can plant along Weaver Street and so on in that area, which is town property. Is there also an equivalent thing? Has there been discussions with the village of Larchmont, which owns the reservoir, for something similar? Or what happened? Because, and I know I've mentioned this before, excuse me, the town ordinance is totally clear that a landscaping plan is required. And the people who prepared this thing, Saratoga, say they are landscapers or landscape designers. And there has never been, that I have seen, a landscape design of any kind whatsoever submitted. It's always an excuse of why we don't have to have one. But the town law, which is not preempted so far as I know by the feds, has never been met. Now I understand the concept of saying, fine, maybe everybody can agree to waive the landscape requirement in exchange for, we'll put some money so that the people who actually have these properties can plant some trees and solve the problem. But at the moment, I don't know that, what the deal is. We're not asking you for money per se. That's not the idea. Just trying to say that repeatedly, that's for the landscaping plan that's called for and never get it.
Well, if I may respond. So I believe the landscaping plan that we've discussed at the last few meetings, it was agreed by all that landscaping on the property that's controlled by Homeland Towers would be of no benefit to anyone.
Agreed.
So that was the reason why we can't provide a landscaping plan, because it's been agreed by all that a landscaping plan would be of no benefit. There was a comment from the Coastal Zone Management Commission, a suggestion that we contribute to a tree fund because the landscaping that has been suggested has been off-site landscaping on properties that our applicant does not control. The applicant is in support of that. I think that would bridge the gap here that we're facing, and that would, solve the problem, which is how can we provide landscaping to areas that the planning board wished to have landscaping that the applicant doesn't control. I think the tree fund solves that issue right there, and the applicant would be more than willing to make a reasonable contribution to the tree fund with respect to the amount of impact.
Okay, that's sort of what I was trying to refer to before, maybe not clearly enough. But there are two communities involved. And every resident of the village of Larchmont is also a resident of the town of Mamaroneck. But the town of Mamaroneck owns a strip along Weaver Street, but not the Larchmont Reservoir. So there are two jurisdictions in question. And solving the issues of the views from the Larchmont Reservoir, so-called, will not be solved by making a contribution to the town's fund. My question really is, have you had a similar discussion, because I assume there was some kind of discussion, with the village of Larchmont, which has a tree fund too, which might solve the same problem. And then then with the village doing its planting on the land it owns. I understand you can't plant on land you don't own unless somebody gives you permission to do it.
We can reach out to them, but no, the application was referred to the village of Larchmont as part of the required referrals of this application, and we've received no contact from the village. We've received no inquiry that they have any interest in this application, but we can reach out to them again. However, this planning board's jurisdiction is within the town of Mamaroneck, and contributions to the village of Larchmont aren't really applicable to this particular application. But we will reach out to the village of Larchmont. The application has been referred to them. We've received no comments of their interest, but we'll follow up.
Fine, thank you.
Mr. Chairman, if I could just suggest, since you established that the village of Larchmont is, or the residents of the village of Larchmont is a village within the town of Mamaroneck. I don't see why, if they haven't come forward and expressed an interest, we can't, that is the town on behalf of the village, if there is a contribution to the tree fund, can't determine whether we wish to share it with the village if they'll use it appropriately.
I think I have no problem with what you just said, Eric. Okay, and if the village doesn't ask for anything, so be it.
We have no objection to providing the money solely to the town and the town deciding how to use it best.
Ron.
I've done planting at the reservoir property before. So I think, that if we find a location that would be appropriate for some trees, there would definitely be, we could definitely use the tree fund, some money from the tree fund to do that.
Okay, so I figured, Elizabeth, you're probably in contact with the people who run the conservancy for the village as well, no? Unless you're the same person.
So be working with the village, with the village staff, in addition to the folks at the environmental center who help, also act as stewards of the property.
So a contribution could be made to the town for use on both the town and the village properties, and that would solve the problem here potentially. Is that correct?
Yes.
Ralph, before you go on, it may not be visible on your screen, but Ron Mandel has been raising his hand.
Yeah, I'm sorry, Ron.
Okay, thank you. No, notwithstanding, Ralph's comments, and I think the value of this potential tree fund, I just do want to point out the fact that I don't believe that even the planting of trees, for example, along Weaver Street, for example, closer to Bonnie Way, which is one of the images in the visual resources package, would help mitigate the visual impact of this proposed monopole. Just for the record, I wanted to state that, because again, no matter how many trees you plant along Weaver, they'll never be able to block a pole that's 125 feet and clearly visible from Weaver Street. Right there, you just passed it. I mean, we see the balloon, and I appreciate the fact that the balloon is somewhat hidden, behind branches and leaves. But the fact is, I mean, we're not going to see a balloon in the future. We're going to see a pole extending from the balloon down. So it's hard to hide that behind a few trees on Weaver.
Well, again, the application's not a monopole. The application is a stealth design tree pole. So the applicants have taken into account the best design for reducing the visibility of the tower. And right now, the best design in this particular area is to disguise the facility as best as possible as a tree.
I understand that. And Mr. Kenny, with all due respect, I mean, I remember I asked, and it was unfortunate that we didn't receive in our packet any, photographs of the other kind of stealth designs that you've installed. It'd be nice to see what it would look like. Not a computer rendering, but an actual image of what's being proposed. If you can please provide that.
We can try to provide that, but again, these things are built to spec. So one facility may not exactly be comparable to another. However, we can definitely reach out and see if we have some comparables we can provide to the board.
That would be great. Again, I'm not asking for the exact, a photo of the exact thing you're proposing to build here, but I'm sure you're getting concepts and elements from other designs that you've installed.
Well, we can look into it.
That'd be great. Thank you.
On the same topic, the photos that we've seen or computer simulations we've seen are the whatever you call it, the monopole or whatever, without the antennas hanging from it. The antennas, which I've looked elsewhere, including the one that's on the hutch, which is far less attractive than what's being proposed here, have the antennas several feet out from the pole, thus remaining pretty visible. And I know I raised this before, but I don't know if I ever got an answer. And that is to what extent through the branch system and the painting of the antennas to match the branches, which you already said you were going to do, can the antennas be made less visible?
Matt, can you express that the photo simulations do account for the antennas as the pole is designed for Verizon?
Yes, off the top of my head, I don't know, David, if you can zoom in on that. The simulation does show antennas.
Get it better.
I would have to count how many we showed in here. I see two levels of antennas that are shown here. Those are the darker spots, and they are designed. David, maybe you can help me out with the term of art, but there is a textured sock, a sleeve that goes over the antennas that has a branching texture, so it matches the color of the branch and as well as some of the texture, and it actually works very well in disguising the antenna to better match the coloration of the branches.
And we did discuss this at the last meeting that when the question was asked if we were painting the antennas, we are covering the sleeves on the antennas that basically will help it blend into the monopine design more, fitted with monopine socks.
Yeah, no, I remember that. So the diagram you just showed us had one set of antennas at the top. Can we go back to the one that we just was shown?
Sure.
Okay, that has the antennas on the outside of the branches. Is that a necessity? Because others will, as opposed to have the branches extend, at least down to, there are 3 or 4 levels of these, beyond the antennas so as to hide them better?
We can look into that, but again, I think the use of the socks and, this drawing right here, the branches do, come out just in front of the antennas, if you can see. And the way that the socks work with these, it'll blend it into the tree. We can look into that, but I believe what you're requesting for the branches to extend further than the antennas, that's already being proposed. And then the added benefit of using the sock coverings help further disguise the antennas and blend them into the monopine design.
Okay, thank you.
If I can make a quick suggestion on that topic, David, it might be beneficial for the board if your team has any photos of what some of these components look like up close. Because obviously the you know, the drawings only show us upscale, but if you guys had any photos, that might help for your next appearance.
Again, I'll look into that, but photos of a different site is not exactly applicable to what we're proposing here. I'll see if we can get something that's close enough and comparable, but it won't be exactly what we're proposing.
Understood. You know, I was just to be clear, I was referring more just to like the sock and, you know, how the sock typically correlates with the fake branches, just so that they can get enough close as to what those components actually look like when they're installed.
Sure, we can try to get something like that. In addition, in the September 30th submission, we know the board has had a focus and a question on the generator that's proposed with the facility and the amount of backup power that it can be provided. We submitted a letter from our engineer who's on the Zoom call with us today, Mr. Burns. The letter says under a worst case scenario operating at 100% power output, that the generator could supply approximately 89 hours of runtime. Again, this is if the generator was running at 100% power output. Bob, I believe you looked at some numbers of what might happen if it was not running at a worst case scenario, but maybe under a more expected scenario.
Yeah, so typically the draw on these sites is around 60%. You know, it's sometimes a little more, sometimes a little less, but the average is about a 60% draw, which bumps up the runtime from 89 hours to 130 hours, which is about 5.5 days. In addition, on the site, there's a bank of batteries, and those batteries are charged by the generator. But initially, there's a charge in those batteries, so it adds about another 8 hours of time. So you're looking at about 138 hours of runtime on that generator with the 500-gallon propane tank, and that's just under 6 days.
Well, can I ask a question based on what you just said?
Sure.
If you take the worst case, because worst case is what the war is about.
Yep.
You have 89 hours, which is 3.5 days, on 500 gallons of propane. What if you had 1,000 gallons of propane? In other words, a bigger tank. According to what I've been told by the town administrator, the fire department would not have a problem with that. And that would provide at least a week. And at the worst case, that's the kind of thing that we now suffer through in blackouts. They can run a week or thereabouts or even longer. If it's not at 100% capacity the whole time, it would last more than a week. If it is at 100% capacity, it would last a week. And it would, to me, at least, it would solve the problem by just having a bigger fuel tank.
We can look into that. We can see if it's feasible to provide a 1,000-gallon tank. However, I believe, you know, what our engineers just stated is that under expected scenario, the facility would approximately run for a week without power. And I think that is unfortunately, we don't control Con Ed, but that is at the extreme end of how long a power outage would likely last.
Not around here lately, because the issue is, and I don't know if you live in Westchester, I don't know where you live, or an equivalent place, but we have had long power outages repeatedly, and a week is short. Different people in different parts of the place get their power back faster. But I know people around where I am, not my building never lost power, but they had 9 to 10 days with no power. Take the Campium at 35, North Chatsworth. So I'm trying to say that with ease or relative ease, and with something which I first thought the fire department would have a problem with, but they don't, just make a bigger fuel tank, you solve the problem. Then you don't, drop the idea of trying to get natural gas. You really don't need it. If because the 1,000 gallons at your projected use would last 10 days at least, and even a maximum use would last at least a week.
Like I said, we can look into this and see if it's feasible.
Yeah, and I'd like to just point out a couple things too, is that, with the 1,000-gallon tank's obviously bigger than the 500, and there's a 10-foot spark zone associated, no spark zone. So it will impact more room in the compound. Now, we may be able to squeeze that 1,000-gallon tank in there with the no spark zone. But with future carrier number 2 coming on board, and if he wants to put in a propane tank as well, there are regulations in terms of how distances between propane tanks and the spark zone that we're taking up with Verizon's tank may end up taking up area that another carrier could use for not only their equipment, but for their propane tank plus the spark zone. I don't know if that made sense, but.
Can I ask a question? Have the emergency departments looked at the amount of area in the compound that's being set aside for our emergency equipment? Because each of the carriers have a fairly large parcel, and then there's this tiny little square for the emergency services. Has anyone from the town or the emergency services looked at that?
We've not received.
Pete, yeah, in talking to the emergency services and having plenty of emergency services co-located at our sites, they usually have plenty of room within that 10 by 10 area. Each of police, fire, ambulance, what have you.
But is it only going to be Mamaroneck, or is it also going to be New Rochelle and Scarsdale? Are there
I've
three?
reached out to Scarsdale. Scarsdale's police is interested in the future in co-locating. And I spoke to Detective Gasly, I think was his name. And we expect a letter from them indicating that interest to co-locate in the future. And police of Mamaroneck is also evaluating the site for redundancy.
That's correct. I was going to offer that, for the town services. I know that our OEM coordinator has been hard to get a hold of. He's going through some medical challenges right now, but I do know that town police have been looking into this location, as well as possibly the highway department. But we are actively reviewing that right now.
I mean, according to what I was told, and that's probably the reason why I didn't get it, that we were going to get a letter by today from the town as to what its requirements were or are. And, apparently it was delayed. But my understanding, and that'll lead to another question, is that they're talking about 2 antennas. That's from Steve Altieri. Which 2, I don't know. And whatever it is necessary to keep them working. And also want to know that the developer will place the mounts for those antennas and the wiring and so on without charge when the antenna goes up, when they do the Verizon stuff, because you know where these antennas wind up. And clearly the antennas will be paid for and the equipment on the ground by the town, from what I've been told. But the work is really no major amount of work while the tower is being built and the other antennas are going up. So would like to get a commitment that the labor and the parts that go with that are going to come from the developer.
We're not ready to commit to that now. We can look into that, but again, there's liability issues. There's issues with how the equipment's installed, whether it's installed properly. I'm not sure if that's something that we would be willing to do or be able to do. This might have to be, from my experience, usually the emergency communication equipment has its own contractor or its own expert install the equipment because they have their own specifications.
Not only that, but there are also warranty issues.
My concern was simply that there's enough space on the ground for the generators and the propane services that the emergency companies would do in the square that you've marked off for them.
Well, especially if they're going to be more than one community. If this is Mamaroneck,
their installations look different. I'm sorry. Pardon? Their installations do look different than the carriers and us. They typically just have one radio each, and that goes within a small shed and is installed on a rack, as opposed to the carrier's equipment, which is larger in size.
But
If
don't those systems also have to have a backup generator and a fuel source and so on, just like the ones for the antennas?
Sound like it.
It depends. The equipment from the municipal emergency services, it's different than the FCC required equipment for. So, and also we're talking right now in speculation. We still do not have an application for equipment to be co-located. The interest is there, but we don't know exactly what the equipment is and what the specifications will be. What we provided is a space for the municipal equipment that is similar to in size to many other facilities that Homeland Towers operates and that has worked for municipal services equipment in those other communities. So what we've provided is a general space, a carve out for municipal emergency equipment based on what we know from past experience. We believe that this will be sufficient.
Have you, in your examples that you're thinking of, have you had more than one municipality utilizing the same space?
Klaus, can you speak to that?
I'm not specifically aware of that scenario, but we've had more than one emergency service share that space. We've had fire, police, volunteer ambulance. Like I said, there's typically they don't take much space at all. 10 by 10 area is plenty sufficient usually.
Okay, well, Rob, would you please take this up with Steve, et cetera, and find out exactly what it is the town has in mind?
I will do that, yes. And,
Do we have an idea when we're getting the report from our consultant?
All right, so I can speak to that. Mr. Manx of Manx Associates had confirmed that based upon the applicant's prior submittal that was made for this meeting, that there was still some technical data that he was lacking in order to complete his analysis. I believe Mr. Kenny had submitted some supplemental information earlier today, which I forwarded on to Mr. Manx. Mr. Manx is currently reviewing it. As soon as that review is done, he has indicated that he's going to provide his findings to the board.
Correct. So we received Mr. Menkes' comments on September 22nd, I believe, and then by email September 29th. So his comments requested that actual drive test data be performed. So the applicants have actually had radio frequency engineers drive the areas around Bonnie Briar Golf Course and the surrounding communities, and to demonstrate the significant gap in coverage that we've documented in our previous reports. We also provided additional responses showing that if the tower's height were reduced, there would be a significant loss in coverage. But if the tower's height were increased, there really wouldn't be a significant gain in coverage, and most of the coverage would overlap areas that are already covered. And we also responded to specific technical questions regarding the information that was used to make the propagation maps. We made that submission today, and we wait for Mr. Menkes' review.
Have you also responded to our environmental planners' comments?
So we just this morning received a comment letter from the environmental planner. We are working on those responses. We'll have that before the next meeting. We do have a concurrence from SHPO stating that there's no adverse effects in the area of expected impact, or I'm sorry, just grabbing the exact language, the areas of potential effects. And we will submit that with our response to the environmental planner's comments, as well as a more detailed response to her specific comments on the cultural resource survey that was included in the September 30th submission.
Okay, so at this point, Rob, I guess you're coordinating all of this. With what David Kenny just said, do we have, or does have, to Liz's issues, responses to everything that we have submitted to him? Obviously, he can't respond to things that haven't been submitted to him yet.
Ralph, I'm sorry, the audio got a little fuzzy there for a moment. If you wouldn't mind repeating that question.
What I was trying to find out is, do we have answers to all the things that the applicant can answer at this point, so that we can get to our consultant to get a report from him, and so that we can get whatever reaction we need from our own internal experts other than, as opposed to external experts.
I believe we received responses to Mr. Mex's requests. I know Anthony Alberry's Topographical Engineering had some comments as well. I'm not sure if those were included in the recent response, but I do believe that Mr. Mex has what he needed. And obviously there's some items that, are still under review with, the emergency services and other items of that nature. I'm not sure if Liz has received any response yet either, but I guess we'd have to confirm with other staff.
Okay, I mean, for example, there were some design issues with respect to the tower, which we'd been told that they would be submitted at the time of a building permit, but our code says they're to be submitted as part of this application. So have they been received?
Referring to the structural design report, no, we have not received the structural engineer's design calculations or the supplemental geotechnical information that was talked about.
The other thing that comes to mind is, I'm not sure if stormwater was addressed on that last submission.
It was requested that we include additional information on the foundation in the most recent submission of the site plan. So Bob, if you could speak to the additional foundation information that was included. I'm going to share.
So the design of the tower foundation will be performed once the tower manufacturer gets involved. We have not performed geotech out there. What I did provide on the drawings, which is what we talked about last time, was a generic tower foundation. I believe somebody was trying to fill out an EAF and needed some information on the excavation. So I gave some numbers and showed it on the elevation for demonstration purposes of a typical tower foundation. But until the geotech's done and the tower company gets involved to design the tower and design the foundation, that's when the calcs are done, and typically those are done at the building permit stage.
And we also submitted in the original submission a letter that certified that the facility would be built in accordance with all federal, state, and local structural requirements. So for the purposes of the application before the planning board, we have certified that the facility will be built to meet all required codes. And we did include information that could color the EAF as part of, what a typical foundation would entail.
Okay, have there been any borings or so on to make sure the foundation will not have a problem being located where you want to locate it? Are there rock issues? Are there other issues at the site in question?
We have done no geotechnical exploration at this point. Whatever issues we encounter, we'll deal with, and we'll make sure the foundation works, whether it's rock removal, whether if it's ledge, we pin it to the rock. Occasionally we have to do a caisson foundation, or the typical foundation is the one I've shown on the drawings.
Okay, well, in that case, Lisa, at some point, please take a look at the code as to, whether the answers we got comply with the town code. On their face, to me, they don't, but you're a council, I'm not. And we, have to work on the code that we have, and the fact that you don't want to submit drawings at this point, or et cetera, doesn't mean that the code can't require them. So I just want to find out from council, and she will get back to you, Mr. Kenny, as to what her conclusion is.
Yeah, Ralph, engineering will also take a closer look at those items too. I think we were under the impression that we were still expecting more information. I know Mr. Kenny's statement that design calcs are not always submitted at the planning board level is sometimes true, but I have seen them come up during the planning board process in the past on occasion. I'm not sure what it is necessary entirely, but I think that there's at least some concern as to getting a better sense of the broader impacts if a deeper foundation technique is required. Would rock removal be a construction method? So there's a couple of things we may have to look a little closer at, but I will look with Lisa at those items.
Okay, what I'm actually getting at with all of this stuff is not my personal view anyway, is not that this tower can't be built and probably won't be built. It's a matter of following the rules that we have to the extent not preempted by the feds. And a matter of whether we are or are not ready as a board at this point to go to a public hearing, because we're still missing a bunch of stuff. And in our normal course of doing things, we get all the information there is to get from the applicant before we ever have a public hearing, so that we know what the answers are going to be to the questions that may or may not come up. And we know that if the public hearing goes well, in all likelihood, that whatever it is that the hearing is about will wind up getting approved, because that's what happens most of the time. So I'd like to hear from the members of our board what you think of this. Don't all speak at once.
Ralph, I'm not a member of the board, but I was, based on what's still outstanding, I thought a list was sent to Mr. Kenny, maybe by Lisa, that kind of compiled all the questions and missing information and so forth. Maybe it would be worthwhile to get something back from them spelling out how each of these things are being addressed, instead of getting pieces of information back.
I have to interrupt. I have not received what's being discussed. So if there's an additional comment letter that was made, we've not received it. The most recent comments we received were this morning when we received from the environmental planner.
I'm not talking about an additional comment letter.
And I would point out that the comments we got from Mr. Oliveri, I submitted a response letter with the last set of drawings on how we responded to each one of those comments.
And I have that letter.
No, I think what was being discussed is a way to make life easier, which is to see if we can gather a list of what is missing, whether it comes from Rob, from Anthony, from Hank, from anybody. Give it to you in one shot, so that you can answer it in one shot, hopefully, and we can finish these back and forth meetings, which run into the night for everybody and nobody particularly loves. So is that what you were proposing, Anthony?
Yeah, that's what I, like a point for point kind of memo back. Maybe I missed it. I don't remember seeing a memo addressing my memo directly.
We definitely submitted that, and I'm going to be pulling it up shortly.
Okay.
Yeah, the letter came in, it was dated September 3rd. It was actually, I believe, before the last meeting.
So my understanding is that the universe of comments from the town consist of those by the environmental planner, our consulting, both Anthony Oliveri and Hank Mankis, that those were the three entities that submitted comments. And I think, David, that you have all of that, the last of which I guess was the memo you got yesterday from the environmental planner.
There was also Robert Wasp's September 8th email, which had a whole list of things on it. Again,
Yeah, I think everything's been sent. I wasn't suggesting that there's any kind of new list. I was just suggesting, compiling it. And yeah, if you could maybe, I don't know that I got that response to mine specifically. So if maybe it wasn't in my packet or something.
Yeah, we absolutely provided it. I'm trying to look for that letter right now, but,
okay.
We'll email it again to the town, but the comments that were provided, and I'll pull them out, sorry, from the town that we've received thus far, with respect to Mr. Wasp's comments, we responded to all of these. The comments were questions regarding if we could provide the land lease agreement. We provided that. If we could provide,
Actually, no, you did not provide the land lease agreement. You provided
summary
of portions of it. And one of the parts, which actually I forgot to ask about today, is who clears the road from Weaver Street up to your site. I asked that of the people at the country club, and they said, well, haven't you seen it in the lease? There's a provision in the lease as to what the applicant has to do. And then I thought, okay, we have two applicants here, right? You're representing two of them. Who has the obligation to clear snow, for example? That's the likelihood, so that you can get in there and maintain these things. And is that on the developer? Is it on Verizon? Is it on the next guy who comes along, to AT&T potentially? When is this supposed to happen? I don't know what's in that part of the lease. That part was not provided to us. I can understand, that I didn't ask the question till now, except it occurred to me when I got the maintenance plan, which I did ask for and you did send, that, okay, you got to get there first. It's a long way from Weaver Street. I mean, there is a provision about that in the lease, is there not?
Again, so just to go to the previous comment that was, our letter in response to Mr. Oliveri's comments, that was submitted in our September 9th submission. And that letter is right here. So we did submit revised site plans, and we actually gave a response to all of the comments. So that was submitted to the board. As far as the lease, we had a request for a specific reason to provide the lease. I believe your request was whether or not we had authority to bring the application, as you had a request if we're not the deeded owner of the property, that we provide some authority with the lease that we can bring this application. Not only did we provide a letter of authorization, but we provided you, excerpted terms from the lease that we thought were relevant to the board. We can look into the request for who's going to clear the end of the access drive, but I'm not sure if that's a particular question that needs to be resolved by the lease. We can just provide an answer to that.
Yeah, I mean, according to the general manager of the club, the entire road is your obligation for clearing for snow, because they basically aren't operating in the winter and they don't use any of that. So since that is necessary, I mean, it's 400 some feet, I think. It's on your drawings. I don't remember the exact distance. It's not just the end. So it matters because you got to get there to maintain it. But, I'm sure there's something in the lease someplace that talks about this. If you could just take a look at some point and let us know.
Sure, but regardless of who clears it, I'm not sure why it's relevant. We'll give you
relevant because we are trying to produce, as with the amount of power, the amount of gas to provide power, something which is going to provide the best protection for the people of the town and vicinity. And since maintenance is required, and you submitted a maintenance plan because that was required, I read it, of course, etc. In order to maintain it, you got to get there. And in order
if I can just,
you got to get trucks there.
If I can just simply answer that we as the we will clear the road. We will maintain the road as it is needed. We will clear the road as it is needed.
So
it doesn't fall on the club. It's not the club's responsibility.
No, I understand that, but we have two applicants right here.
And Mr.
One of the two of them presumably has, I would think it's Homeland.
Correct.
The obligation.
That's who Klaus represents. He's a representative of Homeland Towers. So his response was that Homeland Towers will be in charge of clearing, and that the carriers nor the club.
Thank you. Okay, sorry, I am not aware of who represents whom.
My apologies.
All here other than David.
I can just chime in for a second here, as was referenced. Yeah, I did find the email that I had sent to David Kenny on September 8th, and essentially my email was compiling a bunch of concerns that were discussed at the first appearance for the planning board and other staff concerns. So I think there's some overlap on some of the issues here that are brought up in my email with the comments, posed by Anthony Oliveri and our environmental planner and Mr. Manx. I'm not so sure that I've seen a direct response to all these, but there are some that are still somewhat pending, like not to keep going into details on backup power, but I know we had asked for the alternative of evaluating if a permanent gas service connection was feasible in lieu of all these tanks and the temporary storage. But again, I'm not asking for an answer right now, but we may have to go through this just to make sure that all these items have been responded to.
Sure, we can do that, but again, all the items have been responded to. The land lease agreement, we did provide excerpts from the lease. The revisions to the civil site drawings were provided. We did just now today provide you a letter on the emergency power needs. The landscaping plan has been discussed at several meetings, and we've discussed the tree fund. The profile view drawings, we just provided them in the most recent submission. The tower structural design calculations, we updated and added information to the site plan, and supplemental RF coverage analysis. We did submit additional radio frequency information, and we've even submitted more radio frequency information since we received comments from Mr. Menkes. And the final comment is EAF comments from the town environmental planner, and we submitted a full responsive submission to that on September 30th. So we have made all of these responses, and they've been discussed at several meetings. None of these are new comments.
Okay, then let me try to phrase what I said differently and maybe get a response from people. And that is, typically we get everything we need, and the major thing we're missing at this point is Hank Menke's report, which we have not received.
And photos of what this thing's gonna look like.
Yeah, we're right, and yeah, exactly.
No, you've received photo simulations. If you're going to ask for photos of outside, additional facilities, we can try to provide those, but the application's complete. Those aren't required by your code. These aren't checklist items. The application's complete. Every time we get a request for additional information, we try to be responsive, and we are being responsive and trying to submit responsive to all requests for information that we receive from this board. But the application is complete. It's been complete for a while now. And I hope that the board is continuing the review of this application by scheduling the public hearing that was previously discussed for October 29th.
My position is that we're not ready for a public hearing at this particular point in time. We'll wait. My position is consistent with last meeting. I'm waiting for our outside consultant to make his comments. Once I see those comments, then I think we can prepare for a public hearing. But until we see those comments, I'm not ready to vote for a public hearing.
Okay, Ira, how about you?
I'd like to know what detected a slight tone of impatience in Mr. Kenny's voice. I wondered what the origin of that was, and whether
I apologize if you heard any tone that was not meant, and I apologize if that was received anyway.
I'm being a little bit too subtle. Are you suggesting that we're moving too slowly to be compliant with the federal requirement?
No, I'm not making any suggestion at all. And again, I appreciate this board's time in reviewing the application, but we can only submit responses to comments as we receive them. And if we haven't received a report from Mr. Menkes, I don't think that the applicant should have their application delayed or the review delayed based on the submission of a report by someone that the applicant has no control over.
I take issue with that.
I do as well.
We want to review this application completely. We do not want to waste your time, our time, or the public's time before the application is ready for a public hearing.
Okay, so Ira, what's your bottom line of this?
What precisely is the question, Mr. Chairman?
I guess the question is, does one have a public hearing on October 29, which means we will not have a meeting in between then. We will not have a chance to discuss, for example, the Menkes report, which doesn't exist yet, so far as I know. Or do we want to say, fine, we have a meeting on November 11th. We can review all this stuff. We're having that anyway.
I don't know how we could have a public
promptly
hearing.
thereafter.
I don't know how we could have a public hearing if we haven't had the report from the outside consultant, because I would imagine members of the public who'd want to attend and inform themselves at the public hearing would ask questions that would include, did the town or the board hire a consultant, and what did the consultant say? So it's one thing that we don't have it today, but we don't know, I gather, when we will have it or how far in advance of the suggested date for the public hearing. So I'll sit on my hands for the time being.
Sarah?
I think we should wait for the report from the consultant before we move to public hearing.
Elizabeth?
Well, the only question I have is if in fact we got the report within the next 5 to 7 days, and I don't know that it's coming, I think we could move forward on the 29th. However, we can't have anything on the 29th if we don't have the consultant's report.
Ron?
I agree. I think it's the best use of our time and applicants' time. If we first get the report, review it, and then have the meeting.
Okay, did I miss anybody? I don't think so. So I think the consensus, because we try to work with consensus, and if you want, we'll have a vote, but I don't know we need one, is that we will meet on the 11th, hopefully for the last time. By then, we should have the Menkes report well in advance. Rob, please make sure that happens. And discuss matters there. We may have questions for you, David, from that too. We will ask him to join that meeting so we can all ask, get his interpretation, because a lot of this is too technical for me anyway. And I would propose that we had set a public hearing, assuming all goes well at that meeting, basically as soon after that as notices can be given, which is what, 14 days and some, is it 14 days, Lisa?
Correct, it's 14
Okay,
days.
plus give you enough time to do it. So very shortly thereafter, so sometime that doesn't fall on Thanksgiving in November.
Can I make the request, if the reason why we don't want to have the previously agreed to October 29th special meeting is because the Menkes report may not come in time to review it. If we're already planning to then meet on the November 11th, why can't the November 11th meeting be a public hearing on the condition that the board has received the Menkes report before then?
Well, for one thing, what we had discussed was one application public hearing, because we have no idea whether we're going to get nobody or some vast number of people. You have a lot of people to send notices to, as you know.
Correct.
Okay, and we simply don't know. So the hearing would wind up at the end of an agenda, so that it would start at 10 or 11 o'clock in the evening in all likelihood and run till God knows when. And I don't think that that is a proper public hearing. I think we should do exactly what we told you we would do, which is have a one-issue public hearing. I'm just pulled out a calendar. We can, since it doesn't have to happen on a Wednesday, it's a public hearing. Okay, it can be done, if the 11th is a Wednesday, if you need 14 days after that, I guess the first day that doesn't run into Thanksgiving would be Monday the 30th. I don't know.
You need 14 days after that?
Well, if you go 14 days after that, you get to the 25th, which is the day before Thanksgiving, which I doubt anybody here wants to spend their evening on a public hearing.
No, but here's the question. If we had the report by the public hearing, why couldn't we meet the next day or the day before if in fact they did the notices 14 days before that?
You're saying, for example, we have our meeting on the 11th and we have the public hearing on the 12th or the 13th.
Correct.
Or,
but they send out all of the notices as if they're going to have it. We can always cancel it, correct?
Yeah, or we can postpone it, and I don't think postage is a big expense around here.
I'm talking about why we have to wait 14 days after the 11th.
Well, that's true. There's no reason. Well, we would then have to set a public hearing. I mean, what we did before was propose 2 dates to potentially have a public hearing on. neither one of which was there a motion to have the public hearing on the date because we didn't have the date. But we could at this meeting set a public hearing if that's what the board desires for, well, let me say this, give it a couple of days in case something doesn't happen quite as it's supposed to. Say Tuesday, the 17th.
That's fine.
I don't know if that would work for everybody else. And we are subject to our LMC TV, our local TV station, being able to coordinate these things. I mean, we can't do the Zoom meeting that we're having like here. And that's going to be a very different one because potentially it will be open to a large group of people. Sabrina, you don't have any meeting that you know of on the 17th of November? Is it Tuesday?
We do not.
Okay, David, does that sound reasonable to you?
The 17th of November,
Yeah.
if that's the earliest that the board can provide.
Well, if we start with the 11th, and you got to have a couple of days in case something goes wrong with that meeting. Otherwise, things don't always happen as like they're supposed to. So it just seemed to me that the 17th is a Tuesday. Around here, not much happens on Tuesdays. Hopefully LMC TV is available on Tuesday. And that we would have to confirm and get back to you anyway, because if they can't do it, we can't do it. Francine, do you have anything, or Rob, any indication one way or the other, or something that would preclude the 17th?
I'm looking at my calendar now. Not that it accounts for all conflicting meetings, but I don't see
Do
anything.
we have anything else on the agenda for the 11th right now?
What do we have on the 11th agenda for the 11th right now, or are
We have Villa and the
public
other one.
hearings that I know of? Whatever new things come in, that's all at this point. But I didn't know what would be on the agenda for today until I got the information from Francine last week. I mean, it's hard to tell whether we have an agenda that has 3 items on it, or a dozen items on it. Hopefully, not that. But I mean, the problem is I have no idea how long this public hearing is going to take.
You have no idea?
None. How do I know how many people are going to show up?
I have an idea.
Yeah, what's that?
3 or 4 hours, at least.
I think quite possible. I mean, we do know that the club itself has asked its people to come out in favor. So a bunch of them may do that. And somebody's always opposed to everything. So I really think that if we do something where we can actually have a public hearing at 7:30, when we usually start our meetings, in 4 hours, it's only quote 11:30. What do the members of the board think of that? Because we're the ones who are going to have to set it.
We do it earlier in the day.
People work. I know you'll work too, but we cannot do it during the day.
No, not during the day, but not a start time of, let's say, 6:30 instead of 7:30.
I could live with that. Is that acceptable to everybody?
Yes.
Yeah.
Okay. How's that? David, that would be acceptable to you too?
Absolutely.
Okay. So may I have a motion to set a public hearing on a one-topic public hearing, only on this application, for Tuesday, the 17th of November, starting at 6:30 p.m.
So moved.
Second. All in favor? Aye.
Aye.
Opposed?
Obviously, subject to availability of LMC TV to provide broadcasting.
Yeah, Rob, can you confirm that tomorrow?
I will.
Thanks. Does this work for you too, I assume?
It does. I'll be here.
The motion is done well, I guess on the possibility that they're not available. And since Wednesdays are the worst day for the town, normally, how about if we do this, that in the event that the 17th is unavailable, it's Thursday, the 19th. So that we can at least include it in our motion. We don't have to come back and try to do it again and delay everything a month. That acceptable to everybody? It'd be Tuesday, the 17th, unless LMC TV cannot do it, in which case it will be Thursday, the 19th.
Fine for me.
Tell the applicant whether LMC can do it or not, they can send the appropriate notice, see to the appropriate.
Yes, well, Robbie will do that as soon as it's known, and that way the motion covers whichever of the 2 dates it may turn out to be, with the intent being the earlier one being the 17th.
So the motion is to set the public hearing for the earlier of those 2 dates, subject to the ability of LMC TV to service us.
Right, and to set it at 6:30 rather than our usual 7:30. All in favor? Aye.
Aye.
Opposed? Abstentions? We're done.
Thank you for your time.
And
Thank you.
just noting for the record that John Cuddy is recused, so he did not vote on setting the public hearing.
Right.
Is that why he's smiling on the screen?
Yeah. That's a nice picture.
Thank you all for a fairly long evening.
Thank you.
So I move we adjourn.
So moved.
Second.
Don't have to move that. Lisa said we no longer require a motion, so we're adjourned.
Have a good night.
Good night.
Yeah.